Wrong as a lordship.
You have to.
Second,
You have to hear that entity.
whoever wants to
law,
come is welcome
whose
in
law
this
is
court,
valid.
my lord. Your lordship
Whoever
don't
wants
say
to
no.
intervene, yes.
He really did not call upon you to even
And my lord, I only want to comment on one thing. The letter is addressed of yesterday. Your lordship issued notice 5 months ago. I mean, if you had somebody, you could have issued a letter earlier.
All right. Yes, Mr. Raj.
Completely unnecessary, my lord, to show
Yes,
all this to the court.
So yesterday we were looking at we looked at Navtej. We were on para 470.
Yeah. No, my lord, your lordships asked me to show 469.
Yes.
So I'll come back to 469 at page 235 of the report. 469. I had read 468, my lord. I will start with 469. Citizens of a democracy
Just give us,
cannot be compelled to have their lives
give us a moment.
pushed into
Mr. Rodgi, just one second.
Just give us PDF page.
PDF
my lord,
1048.
1048.
PDF will be 1048, my lord. Compilation page is 1017 and the reports page is 235.
Compilation is
Which compilation is this? Volume?
compilation 1.
Compilation 1, my lord.
Compilation 4.
Compiling
Compilation 4, volume 1.
4 is all the judgments.
4 is foreign judgment.
Foreign judge.
4 is foreign
Foreign
judgment.
judgments.
So in that, volume 1 has
Volume 1.
volume, all the Puttaswamy, etc.
I was reading from that yesterday, my lord.
No, we just lost track. 104.
Your lordships have?
469.
My lord, does Justice Call have it, my lord?
Yeah.
little improvement from
My lord, let me start with respect from 468, my lord. The contextually 468.
We got encouraged by lordships for our efforts.
Mr. Dwivedi, I hope you are also working on your iPad.
I thought I'll
468.
Chief has persuaded me to do.
I'll try to persuade my lords, my colleagues.
The exercise of the natural and inalienable right to privacy entails allowing an individual the right to a self-determined sexual orientation. Thus, it is imperative to widen the scope of the right to privacy to incorporate a right to sexual privacy to protect the rights of sexual minorities. Emanating from the inalienable right to privacy, the right to sexual privacy must be granted, it's important now, the sanctity of a natural right and be protected under the Constitution as fundamental to liberty and as a soulmate of dignity. So my right now, my lord, is cast in stone by first the 9 judges and this. And if I may say so, my lord, in retrospect, I was thinking, in some measure, we are revisiting this issue, though this issue is decided. So, my lord, that's why I said, my lord, when we request a declaration from my lordships, the declaration should not only be a badge, that I wear a badge by saying that the Supreme Court has given me the right to say that I am married. But, my lord, it must at least go forward, even in some limited extent, not, my lord, the entire panoply of all the laws, but at least, my lord, in those laws which are otherwise secular, and which do not touch, my lord, personal laws, where that right has to flow and give me something real. I have made a list of 4 or 5 items, my lord, as an example. Take, my lord, Payment of Gratuity Act. Other acts will provide pension. They provide, my lord, only to a spouse where the underlying thing that you are married. I am going to give you, my lord, some of them. One of them, my lord, is the, hold on. I'll give you, my lord. One of them is judge's pension. A judge's pension will go to a spouse. Now, a spouse presupposes that you have to be married. So if one of us, my lord, becomes a judge and then he gets a pension, tomorrow an issue will arise whether you are going, who will get the pension? My lord, for example, under the Income Tax Act, a gift is exempt from tax, my lord, as between members of a spouse which predetermines, my lord, a marriage. Now, if you're going to do that, how will that work, my lord? So there are a large number of acts. So the secular acts, where, my lord, this issue doesn't arise of, my lord, personal laws. So the effect or declaration of marriage must flow to get us real rights, where, my lord, these day-to-day things, at least in secular parts, are, my lord, involved. Motor Vehicles Act, Gratuity Act, Pension Act, this is, my lord, Juvenile Justice Act provides for, my lord, adoption. Says you can't adopt. As a living, you can't adopt unless you are married. So all those, my lord, those at least it must flow. Otherwise, what will happen? I'm sorry to use the phrase, I get a declaration, I get a badge. 5 years ago, I got that there will be no criminalization. After 5 years, I get this badge. Then, my lord, when I go somewhere, again those problems arise. They say, no, Supreme Court hasn't given you anything. Given you a badge of being married, fine. In society, you can go around and say, I am a couple who's married. But what is the real impact on the ground? Therefore, my lord, I have framed one or two reliefs which I'll indicate. I'm only saying, my lord, idea should not be to go on revisiting the same issue from Puttu Swami and Navtej, back and forth, back and forth. And we should only, at the end, if your lordships give me some, my lord, declarations, as and when in some other issues something has to be fleshed out, it will come back to court. Nobody can, my lord, think of impossible.
String of litigations.
Yes.
Incrementally, as you call it.
Yes.
So rather than going at it whole hog.
Yes.
Whole hog you feel is a problem.
Yes.
Why is it a problem?
No. I am not saying it's a problem.
You don't want, because you don't want to open up the other fronts right now. You feel, what is the reason? You feel it's a distraction?
No, but I'm only saying only personal laws. I'm only saying
The point is, there is an organic hole in this.
yes,
That's one point is,
yes,
get a declaration, then you say that in some of these, what you term as secular, or
I term them as secular, non-personal.
so far so good.
Yes,
But when it comes to personal law, this will also implicate personal law, isn't it? Because some of your
some of them will argue, my lord.
Yes.
Menka
now,
wants to argue.
Therefore,
You don't want. All right.
you may not argue. You have strategic reasons why you will not argue. But this court will have to engage itself once more, twice more, maybe 3 times or 4 times more.
Yes, absolutely right.
Each one of these. The question is then we are not looking at it as a whole. We are looking at it in a truncated manner, which means that we, perforce, for the sake of, let's say, convenience or clarity, we say that we confine this declaration or whatever relief you are seeking to the Special Marriage Act, right? Which means that others who do not wish to or are not aware of this form of marriage, and I use these words very carefully, who are not aware of this form of marriage, of this going through the civil form of marriage, we can't presuppose, we can't assume that everyone knows this. They are denied this, right? Either they choose their religion or whatever. If they choose to, then they are out of this. So that is one aspect.
That is
Second aspect is they intersect with personal law even here. So keep that in mind when you make this.
yes, my lord.
Yes. I'll tell you later. Yes, I appreciate, my lord, for your lordship's comment. So now 469. Citizens of a democracy cannot be compelled to have their lives pushed into obscurity by an oppressive colonial legislation in order to ensure the sexual and gender minorities' fulfillment of their fundamental right. It is imperative to confront the closet and, as the necessary consequence, confront compulsory heterosexuality. Confronting the closet will entail reclaiming markers of all desires, identities, and acts to be challenged. It also entail ensuring that individuals belonging to sexual minorities have the freedom to fully participate in public life, breaking the invisible barrier that heterosexuality imposes upon them. The choice of sexuality is at the core of privacy, but equally our constitutional jurisprudence must recognize that public assertion of identity found in sexual orientation is crucial to the exercise of freedom. But I submit 469 will fully apply, and instead of the words colonial legislation, we can use, Milord, the words colonial mindset. It is that mindset, Milord, which started from then. Society has evolved. Your Lordships, Milord, struck down the barrier 5 years ago. But some parts of that mindset remain, which is evident from the stand of the respondents, including that of the states. And this mindset is, Milord, is implicit in the ground or at the ground level whenever we go to public spaces, and in the so-called, Milord, the secular laws which I'm mentioning, which also will have to be read in accord with the declaration, if your Lordship so grant the declaration. In other words, I will propose at the end, but I will just preface. Milord, wherever husband and wife is used, make it gender neutral by using spouse. Wherever, Milord, man and woman is used, make it gender specific, gender neutral by saying, Milord, person. And I will give you, Lordship, examples in the Special Marriage Act itself. So kindly, Milord, note this. Husband and wife should be used as spouse, and man and woman should be used as person. A large part of this, Milord, will solve our projected interpretation, Milord, of the Special Marriage Act. And what is good here must also apply across, Milord, the spectrum, at least of the acts, Milord, the examples of which I'm talking about. So that's why I said, Milord, 469 will fully apply by removing legislation into a mindset which is evident even today. Then, Milord, the Lordship turns 471. 471 talked about reputable and disreputable sex. Kindly see, Milord, the last line of that page. If one accepts the proposition that public places are heteronormative and the same-sex sexual acts partially closeted, relegating homosexual acts into the private sphere would in effect reiterate the ambient heterosexism of the public space. Which means, Milord, in other words, the rule of majority in public spaces. It must be acknowledged that members belonging to sexual minorities are often subjected to harassment in public spaces. The right to sexual privacy, founded on the right of autonomy of a free individual, must capture the right of persons of the community to navigate public places on their own terms, free from state interference. What I'm really requesting, Milord, for a declaration of marriage is really a paraphrasing of this. When I walk into a public space, I walk into the public space with my partner, knowing that the law in the state recognizes this union as a marriage. Nobody will raise a finger of stigma against me. I walk into this public space. I walk into, Milord, public employment. I walk into private employment. I walk in, Milord, for pensions, gratuities, etc. That I am equal to the heterosexual group. And it's not that the heterosexual groups, Milord, wishes or desires or their orientation is one which is correct, and all others, Milord, are incorrect in the same phrase as reputable and disreputable in 471. So this started with, Milord, the negative part, that you don't do this. I am saying let there be a positive affirmation of the fact that since we are equal, created by judgments of this court from Puttoswamy downwards, from Nalsa downwards, if we are equal, Milord, require an affirmative, Milord, nod from the court that you are equal, marriage will be equal, walking into public spaces, public employment, private employment will be equal. There will be no stigma. You will not be treated as lesser mortals, as was being suggested yesterday by one of them. And therefore, there will be full enjoyment of the right to life, dignified, privacy in my own house, in public spaces, in public employments. That is what, my lord, that is the adversity which we are facing today. I'm only trying to paraphrase the adversity which we are facing today. You go to a school, you write, my lord, parents, names, passports. All those things, my lord, create issues. All those things create issues. Because that's how, my lord, the concept has been. But concepts have evolved. We are not in the same position. I don't blame the 54 Act. My lord, when it was framed, that's how it was. But from 54 till today, my lord, we are 75 years down.
Okay, see what Brother Bhatt said. There will be moments, there will be incremental.
Yes, I agree.
They will take time. One fine day, everything cannot change. That must be kept in mind.
I know, but my lord, some amount
But
of real.
once, if you succeed, and the status of a marriage is recognized, and if somebody doesn't follow that status of the marriage in another thing, then it's a, I would say it's a violation of the order of the Supreme Court, if we agree with you.
Yes,
If that is the position, then certain other changes will take some
I have no doubt.
step,
But,
more time.
my lord, I entirely agree. I entirely agree. But it should not be, I am at the absolute threshold. I am saying it should not be only, my lord, with that declaration that I go away. I should get some real benefit, don't call it benefit, some real filtering down of the effect of the order of this court.
If you succeed, and it is held that under the Special Marriage Act,
Yeah.
this is a marriage which can be registered, that itself the registration is what you get.
I appreciate, but my lord, in several acts, I mean, what I'm trying to say is, my lord, it's like saying that consequential effect will follow.
It will,
Something like that, my lord. If I may show, my lord, I have tried to frame, give copies.
there may be,
I have tried to frame in my own words.
you are saying that the consequences of registration of the marriage
The other side.
in different scenarios will arise.
Yes, yes, yes.
Arise.
But just kindly see, my lord, I have tried to frame it, subject to your lordship's pleasure. If I succeed, then I may get something like this. Are entitled to marry under the Special Marriage Act, regardless of their gender identity and sexual orientation. This is the main declaration. The court may be pleased to direct that the marriage will be solemnized under the provisions of the Act. This is an adjunct of item 1. The words
So the first three.
yes, yes. But my lord, I am more interested in 4. Have a look at 4.
I said 4 is a consequence of us.
Yeah, my lord, 1, 2, and 3 are really, my lord, paraphrasing the same thing. See 4. This I respectfully submit, my lord, subject to your lordship's pleasure. The court may be pleased to direct that all laws where rights, duties, obligations, and privileges flowing from marriage are conferred to a heterosexual couple married under the, sorry.
Same thing. But you are saying that you want a specific
Explicit,
declaration. So
my lord.
according to you, the area of litigation should not be so wide that it creates a problem.
My lord.
And though you're confining it to the special marriage,
Yes,
you are saying whatever the consequences of registration
yes, yes.
must be available
I
elsewhere.
am very grateful. My lord, we spend a lot of time in very carefully drafting, my lord, within the contours. Because it should be explicit, my lord. Otherwise, every time, my lord, you start somewhere, you come up to the Supreme Court, 5, 7 years go by, our lives are in any case passing by, my lord, it becomes very difficult. I am not saying, my lord, that this struggle will end today. It can't end. But if we succeed, we should get an explicit declaration in terms of 4 or as modulated by your lordship, which flows from 1. Then, my lord,
Mr. Rohati, perhaps you may want to look at para 478 and 482.
yes, I was going to. My lord, I also wanted to read 472.
470.
It's very important. Very important because of the heading. My lord, see, deconstructing the heteronormative framework. I am again and again, my lord, hitting this part because we are being buried under the pressure of the majority. Wherever we go, wherever we stand, wherever we apply, I am buried under that, my lord. Oh, look, this is abnormal. What is normal is what is majority. But that is not the law, my lord. That's a mindset. That is not the law, but that's a mindset which is troubling us, my lord, in our daily lives. This is only an example to say public space, this, that. But that's what is troubling us, my lord. Therefore, my lord, the importance is deconstructing the heteronormative framework. This is what I am driving at. In the absence of a protected zone of privacy, individuals are forced to conform to societal stereotypes. Puttu Swami has characterized the right to privacy as a shield against forced homogeneity and as an essential attribute to achieve personhood. So I have that shield. That shield must be made explicit that I will not, my lord, be traumatized or stigmatized only because I don't conform to the heteronormative majority. Then, my lord, after the quotation of Puttu Swami, towards placidum F, this court has recognized the right of an individual to break free from the demands of society and the need to foster a plural and an inclusive culture. The judgment of 4 judges in Puttu Swami said this. Kindly leave this, my lord. Kindly come to 474 for a few words. The right to privacy enables an individual to exercise his or her autonomy away from the glare of societal expectation. The realization of human personality is dependent on the autonomy of an individual. In a liberal democracy, the recognition of the individual as an autonomous person is an acknowledgement of the state's respect for the capacity of the individual to make independent choices. The right to privacy must be construed to signify that not only are certain acts no longer immoral, but there also exists an affirmative moral right to do them. I rely a lot on this part because the immoral part is now gone. So the negative and the positive. That's how we have our constitution also have affirmative, Milad, roles. Then, Milad, there's a quotation by Richards. Your Lordship may then turn 478, Milord, and 479. An individual's sexuality cannot be put in boxes or compartmentalized. It should rather be viewed as fluid, granting the individual the freedom to ascertain his or her own desire and proclivities. The self-determination of sexual orientation is the exercise of autonomy. Accepting the role of human sexuality as an independent force in the development of personhood, acknowledgement of crucial role of sexual autonomy in the idea of free individual. Such an interpretive of autonomy has implications for widening applications of human rights to sexuality. Sexuality cannot be construed as something the state has the prerogative. But this is important. Let me read this right again. Sexuality cannot be construed as something that the state has the prerogative to legitimize only in the form of rigid marital procreational sex. This is exactly, my lord, the argument of the other side. Biological man, biological woman, their union is marriage. Marriage will lead to procreation. That is the order of nature and nothing more. That is exactly the argument even today. That's why I say, my lord, in some ways we are revisiting it. Because apart from criminalization, I still face, my lord, these problems. Sexuality must be construed as a fundamental experience through which individuals define the meaning of their lives. Human sexuality cannot be defined narrowly in terms of function as a means to procreation. So, my lord, not the narrow or a pedantic view. To confine it to closed categories will result in denuding human liberty of its full content and a constitutional right. The Constitution protects the fluidities of sexual experience. It leaves to consenting adults to find fulfillment in the relations, diversity of culture, among plural ways of life, infinite shades of love and longing. By criminalizing consensual acts who wish to exercise their right, state is denying a citizen the right to intimacy. The right to intimacy emanates from individual prerogative to engage in sexual rights, etc. Then, my Lord, Shakti Vahini. That's important. My Lord, I will not read Shakti Vahini because Shakti Vahini is quoted here. But my Lord may note, my Lord, on the side, there are three judgments. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. I'll repeat, my Lord. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. These are four judgments which lay down and reiterate one principle, that every person is entitled to marry a person of his or her own choice. If it applies, Lord, to the heterosexual group or majority, I respectfully submit it will apply equally, my Lord. To us, we may be a minuscule minority, but having the same rights are entitled to the same declaration granted, my Lord, by this court in these four cases. Then, my Lord, 480. In Shakti Vahini, a three-judge bench of this court issued a directive to prevent honor killings at the behest of Khap Panchayat and protect persons who entered into marriage that did not have approval of Panchayat. So Panchayat can be Panchayat, community, whatever you call it. The court recognized the right to choose a life partner as a fundamental right. The learned Chief Justice held. When two adults consensually choose each other as life partners, it is a manifestation of the choice which is recognized in Article 1921. Such a right has a sanction of constitutional law. Once it is recognized, the right needs to be protected, cannot succumb to the conception of class honor or group. Then, Milord 481, Shafin Jahan. Shafin Jahan, this court set aside a Kerala High Court judgment which annulled the marriage of a 24-year-old woman with a man of her choice in a habeas corpus instituted by the father. The court upheld the right to choose the life partner. The Chief Justice held, expression of choice in accord with law is an acceptance of individual identity, curtailment of that expression and ultimate action emanating therefrom, or the conceptual structural of obeisance to society will destroy individualistic entity. The social values and morals have their space and are not above constitutionally guaranteed. One of us, Chandrachud J, recognize the right to choose a partner, the important facet. The choice of a partner, whether within or outside marriage, lies within the exclusive domain of individual. Intimacies of marriage lie within a core zone of privacy which is inviolable. I want to repeat this line. Intimacies of marriage lie within a core zone of privacy which is inviolable. The absolute right of the individual to lose a life partner is not in the least affected by matters of faith. Social approval for intimate personal decisions is not the basis. So majority is not the basis. It is my right. If it is the right, my lord, of the heterosexual group, I would respectfully submit it is jolly well, my lord, our right, because we are, my lord, equal human beings entitled to the benefits of the Constitution in the same manner as anybody else. Then, my lord, the judgment in Shafin Jahan delineated a space where an individual enjoys the autonomy of making intimate personal decisions. The strength of the Constitution, therefore, lies in the guarantee which it affords that each individual will have a protected entitlement in determining a partner, choice of partner to share intimacy within or outside marriage. We are talking, my lord, of within today. Outside, my lord, in any case is available. In furtherance of the Rawlsian notion of self-respect, your lordship may see, my lord, last four lines of this para, just above platism G. This institutionalized expression to love must be considered as an important element in the full actualization of the ideal of self-respect. Social institutions must be arranged in such a manner that individuals have the freedom to enter into relations untrammeled by the binary of sex and gender and receive requisite institutional recognition to perfect their relations. Therefore, my lord, when I say I request for a declaration that we are married, we have to be married under this act, and the state will recognize and register. That, my lord, will be requisite institutional recognition, which will, my lord, follow from the court's declaration of the law under Article 141 and include, my lord, their acceptance, which will be followed by the acceptance of society. My lord, society accepts what the law is. Sometimes the law takes a lead. And I gave your lordship the example of Hindu widows' right to remarry act, which came in the 1800s. There's law acted with alacrity. The society was not ready. It's not ready, my lord, even till early 1900s. Widows remarriage. There, the law acted with alacrity. Here, we need, my lord, to push the society. Push the society to acknowledge us as equals in all respects, because the Constitution says so. And the moral authority of this court, it is not only legal authority, my lord. This court enjoys moral authority. It enjoys public confidence. Judgments of the court and the wisdom and the prestige of the court depends on public confidence. The public has confidence in the court. It's not a case where the public has no confidence, but they are bound to follow only because, my lord, there is a decree of the court. The decrees will be violated by people if people don't have confidence. So, my lord, we rely on the prestige and the moral authority of this court, apart from Article 141. That when the highest court of the land has said that there will be no 377, that you will have a right to marry, that there will be no discrimination in public places. It is that, with great respect, my lord, whether Parliament follows it up with the law or doesn't follow it up with the law, that is what will drive the society in times to come, 2 years or 5 years, whatever it be, to accept this group as a fully homogeneous group with their differences and diversities within one whole. As Justice Bhatt used the phrase, not one whole. That's how, my lord, that's what we are looking at.
They want us to settle.
My lord, my friend is right in saying, our parents have by and large accepted us. We are outside the closet. So we have gone through the process with our parents already, who belong to an earlier generation, to whom it was not the norm, as we understand, because the closet, my lord, was not opened 50 years ago. They have accepted. They want them to settle. They want them to have a family. They want them to have the same recognition, my lord. They don't want them to be ostracized. That the children are ostracized and the parents are ostracized. Oh, you have children who are not normal. So the ostracism will reach there also. It may reach their close friends. All that, my lord, has to be wiped out if the constitutional goal of the preamble, as reiterated by this court in Nalsa, Puttuswamy and Navtej, my lord, have to be given full effect.
These petitioners, their parents.
My lord, in my case, the first case, the ceremony was conducted by the parents, my lord, 10 years ago. So they also, my lord, went through some kind of transformation or whatever you may call it.
By more people.
Yes.
Yes.
And they had a reception in their
They had a reception.
in their hometown.
They had a reception. Some people, my lord, I have read, because you can't get married here, they go abroad and get married. Get a certificate from there. So there are all kinds of, my lord, situations.
It's a small town. 30
Yes, this was a small hometown. Yes.
30.
Then, my lord, now, my lord, something very important. Kindly turn, my lord, to para 553. There is, my lord, in Justice Chandrachud's opinion, a huge discussion of foreign cases, but para 553 is, my lord, US versus Windsor relating to DOMA, which I had given in that chart. So that description is here, my lord. It's important to read that.
Because Nepal, recently 2 weeks ago, another judge from Nepal has come with translation by tomorrow.
Only one more thing, my lord. Mr. Kirpal tells me just above 551, there is a reference to Nepal, my lord.
Yes.
There is a reference to Nepal just above para 551.
What is that? Sunil.
Yes.
Sunil Babu Pant.
Just above para 551.
550.
550.
Lord, we'll get this translation tomorrow. A judgment was.
This is a quote. Fine. After this, another.
After this, Lord, another thing has come yesterday
2 weeks ago.
or 2 weeks ago. We are going to translate it and, Lord, try and give it to you.
Nepal
Lordship.
Supreme Court.
Yes, ma'am. Yes.
Which para? 5?
50.
I was reading, Lord, 2 lines above 551. In concluding, the court directed the Nepalese government to enact new legislation or amend existing legislation to ensure that persons of all sexual orientations and identities could enjoy equal rights. So now there is a fresh judgment reiterating this position, and we will translate and give it to Lordships tomorrow or day after. So it's not a case of urban elitism. Say from Nepal, not certainly not urban elite. Now say 553. In 2013, the US versus Windsor, the US Supreme Court considered the constitutionality of Defense of Marriage Act DOMA, which states that for the purpose of federal law, the word marriage and spouse referred to legal unions between a man and a woman. Windsor, who had inherited the estate of her same-sex partner, was barred from claiming federal estate tax exemption for surviving spouse since their marriage was not recognized. Kennedy J., writing for the majority, held that restricting the federal interpretation of marriage and spouse to apply only to opposite sex unions was unconstitutional under the due process of the Fifth Amendment. In the DOMA, it's DOMA's unusual deviation from the tradition of recognizing and accepting state definitions of marriage operate to deprive same-sex couples of the benefit and responsibility that come with federal recognition. It's exactly what I seek, my lord. I respectfully submit, my lord, it is exactly what I seek from your lordship. This is strong evidence of a law having purpose and effect of disapproval of a class recognized and protected by state. DOMA's about purpose and practical effect are to impose a disadvantage, a separate status, so a stigma upon all who enter into same-sex marriage made lawful by the unquestioned authority of the states. So the laws of the states of the US was at variance with DOMA. That you also find in my chart also. Then 554 below. Obergefell. 2 years later in Obergefell, while analyzing precedent of decisions of US courts recognizing same-sex marriage, Kennedy J. observed, a first premise of the court's relevant precedent is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy, like choices concerning contraception, family relationship, procreation, child rearing, all of which are protected by the Constitution. Decisions concerning marriage are among the most intimate that an individual can make. Kennedy J. expressed the need to go beyond the narrow holding in Lawrence, this is that Lawrence, Texas case, towards a more expansive view in Obergefell. Lawrence invalidated laws that made same-sex intimacy a criminal act. But while Lawrence confirmed a dimension of freedom that allows individuals to engage in intimate association without criminal act, it does not follow that freedom stops there. Outlaw to outcast may be a step forward, but does not achieve the full promise of liberty. This is exactly, my lord, history repeating itself here. Your lordships have, my lord, annulled 377 as it was annulled in the case of Lawrence. But it can't stop there. It has to go forward. It has to go forward, my lord, with a declaration that we are entitled to the same rights of marriage as anybody else, so that we can walk, my lord, in public spaces. Now, my lord, yes. Now, then, my lord, next passage is very important. By a 5:4 majority, the Supreme Court ruled that the fundamental right to marry is guaranteed to the same-sex couple by the due process and the equal protection clause of the 14th Amendment. Commenting on the right to marriage, Kennedy J. noted, "Not this definition is classic. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. It would misunderstand these men and women to say they disrespect the idea of marriage. They are pleased that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one's civilization's oldest institutions, namely marriage, my lord. They ask for equal dignities in the eyes of the law. The Constitution grants them that right.
From your own marriage, like for you, no relationship has been.
So, my lord, if this is good for society as a whole, it has to be good for us. It has to be good for us. And there is no reason that we should not be included in the whole. We should not be included in the whole or the wholesome, my lord, group of society. My lord, now, my lord, the principles at para 561, that is, my lord, the crux. The principles, and then one or two more passages, and we are done with this. Kindly turn to para 561, my lord. 2 pages down. From an analysis of comparative jurisprudence from across the world, the following principles emerge. Sexual orientation is intrinsic element of liberty, dignity, privacy, individual autonomy, and equality. Intimacy between consenting adults is beyond the legitimate interest of the state. Then we'll at point 5. Point 4.
When to read all that?
Yeah, I'll read all of them. Yes, I'm grateful. 561.2. Intimacy between consenting adults of the same sex is beyond the legitimate interest of the state. Sodomy laws violate equality by targeting a section of the population for their sexual orientation. Such a law perpetrates stereotype, lends authority of the state to societal stereotypes, and has a chilling effect on the exercise of freedom. The right to love and to a partner to find fulfillment in a same-sex relation is essential to a society which believes in freedom under a constitutional order based on rights. Sexual orientation implicates negative and positive obligations on the state. Not only requires the state not to discriminate, but calls for the state to recognize rights which bring true fulfillment. This is the affirmative part, my lord. The earlier part was the negative part, or the negative injunction. The constitutional principles which have led to decriminalization must continuously engage in a rights discourse to ensure that the same-sex relationship find true fulfillment in every facet of life. I pause here for a minute. This is what I am driving at. I require beyond the badge. I require this, my lord, I respectfully submit. Beyond the badge that I am married. Every facet of life where we face pitfalls when we go outside, my lord, the courtroom and deal with, my lord, like ordinary mortals. This is what we, my lord, face. The law cannot discriminate against same-sex relationship. It must also take positive steps. This is the affirmative part. The state should rather, my lord, come forward and say, all right, we accept gracefully, not grudgingly. The solicitor referred to the affidavit filed in Navtej. We were in Navtej. The affidavit said we leave it to the court. But the court commented on it in Navtej that we wish that you should have taken a stand in just leaving it on our shoulders. So it's not a matter of grace that the court said there, oh, we leave it to you. That's what the comment is in Navtej, Milad. Now, Milad, 564. This evolution has enabled societies governed by liberal constitutional values such as liberty, dignity, and privacy, equality, and individual autonomy to move beyond decriminalization of offenses involving consensual same-sex relationships. Decriminalization is, of course, necessary to bury the ghost of morality, which flourished in a radically different age and time. I submit, my lord, history is repeating itself. This was only 5 years ago. But decriminalization is a first step. Please mark this, my lord. Kindly read, my lord, the conclusions with this. If this is the first step, the affirmative steps remain. And I submit, my lord, that the prayers that I respectfully seek from your lordships are affirmative steps which will help me lead a dignified life like any other person. Then, my lord, then your lordship may see only one more.
So the last four lines of the
Yes, my lord, I'll read.
Constitution principle, yeah.
Yes, sorry, my lord, I should have read
51.7.
those. I should have read those.
564, 564.
What was they reading? After the first step, the constitutional principles on which it is based have application to a broader range of entitlements. The Indian constitution is based on the abiding faith in the constitutional values. In the march of civilizations across spectrum of compassionate global order, India cannot be left behind. My lord, we have to at least go hand in hand with Nepal. Let's forget anything else. My lord, we are in this region. Let's not talk about the America. My lord, in the US also, a large part of the society is very conservative. Large part. That's why, my lord, you add this DOMA and this, that. And the fact that now in the recent past, they have gone back, my lord, on abortions. They have gone back on abortions. It's not as if that, my lord, they being a industrialized country, they are very much ahead. The entire South, the rednecks as they call themselves, they are conservative.
After Obergefell, they have
So after Obergefell, it has been accepted
An act now.
and they have passed an act now. I mentioned that.
opinion changes.
So things change when the moral authority of an institution says that this is how, please, you look through this prism of gender neutrality. Do not look through the prism. Milord, sorry to go back. This Victorian morality issue, Milord, came in 1800s when, Milord, Mr. Macaulay framed this law. You go back to Indian text for hundreds of years, Milord, you go to Khajuraho, go to other places. You see, Milord, these acts are depicted on the walls for thousands of years. That remained, Milord, the concept of morality. It was not, Milord, this Victorian morality which was in India for 1000 years. Our morality was very, very different, far more advanced, not Victorian, not stereotyped, not stigmatized in this form, not, Milord, this formal thing. You can go to so many places and see. But when, Milord, it changed, we have had a succession from, Milord, Lodi dynasty. Lodi Gardens, Milord, dynasty, 1000 years old. Then came, Milord, the Mughal dynasty in the 1500s when Babur came. Then came the British. They occupied India. They imposed, Milord, their code and their moralities. So the society has traveled, Milord, through, I mean, Milord, twisting, if I may say so, twisting sands of time. What we were thousands of years ago, what we were, Milord, in the Mughal period, what we were, Milord, in the British period. And that British period stuck because they made the laws. They conquered India. India became one, Milord, dominion, like Africa, like many other dominions. We became a dominion. And those laws were imposed on us. Those Victorian morals were imposed. I am not on a debate, Milord, what is right, what is wrong. But that is how the shifting sands of time have, Milord, gone over thousands of years. That's why these words are important. That in the march, Milord, in this march, India can't be left behind. And more so, Milord, at least we don't have a debate like England. They don't have, Milord, a written constitution. So it's a matter of debate what the conventions are or what they are not. We have a written constitution like the US. Our constitution is very, very clear. And this, Milord, golden thread, if I may use again, Milord, the preamble 14, 15, 16, 19 and 21 is now cast in stone by several judgments of this court on secularism, pluralism, constitutional morality, no right, Milord, of the heterogeneous majority to steamroll the minority. And in the recent past, we start from Nalsa. I can go back, Milord, to a large number of judgments. But then that debate, Milord, will unnecessarily go on. We don't need that because there is no discordant note. Wherever there was a discordant note, my lord, your lordships have corrected. MP Sharma had a discordant note. And MP Sharma is of the 50s and 60s, my lord. Your lordships have corrected. My lord, the Chief Justice, my lord, also corrected. ADM Jabalpur. So discordant note. One discordant note, MP Sharma, another discordant note. They have been corrected by this court. So, my lord, this court has proceeded in the last 70 years, by and large, on one track, upholding the values of the Constitution, talking about constitutional morality, talking about the fact that if one man, my lord, is discriminated, he can come to the Supreme Court, notwithstanding that, my lord, hundreds and crores stand one way. One man has the right to come to this court and he need not wait for Parliament. Because this court is the guarantor, my lord, and the protector of fundamental rights. The lordships have said repeatedly. Repeatedly. I mean, you don't need to cite cases of that. So if that is, my lord, the position, and India has to go forward, this court takes the lead with its moral authority and legal authority in providing a declaration saying that this is the next step after 377. Look, Mr. Society, this is the norm. Follow this norm. Remove the dogma. Remove the stigma. That is why, my lord, your lordship said, give wide publicity. That's not normally, your lordship don't say that normally. The reason is you are dealing, my lord, with something which is a little out of the normal. It's not, my lord, a case of property or, my lord, money going here or something. It's not one of those cases. It's a very different case. So the obligations, my lord, rest heavily on this court because of its moral authority and the public confidence in the court, more than, my lord, the legal part. Now, my lord, para 600 is very important. Kindly turn to para 600 and 601. And then, my lord, 2-3 more paras, then we are done with this. And the last para of Justice Indu Malhotra, which I will read, my lord, that we owe an apology, etc. But, my lord, para 600. Constitutional morality requires in a democracy the assurance of certain minimum rights which are essential for free existence to every member of society. The preamble to the Constitution recognizes these rights and liberty of thought, expression, belief, faith, and worship, and equality of status, opportunity. Constitutional morality is the guarantee which seeks that all inequality is eliminated from social structure, and each individual is assured of the means for reference to the rights guaranteed. Constitutional morality leans towards making Indian democracy vibrant by infusing a system of brotherhood. That is, your lordships are now talking about fraternity. This brotherhood takes you back to the principle and phrase fraternity, my lord, in the preamble. Brotherhood comes from fraternity. There is no other phrase of brotherhood in the Constitution. Your lordship may only note, fraternity comes, my lord. Fraternity and brotherhood is the meaning of one or the other and is relatable to the Constitution. Class, race, or brotherhood among a heterogeneous population, belonging to different classes, races, religion, culture, caste, and section. Constitutional morality cannot, however, be nurtured unless as recognized by the preamble. So, my lord, emphasis on the preamble, which became a part, my lord, was declared as a part of the Constitution. There exists fraternity which assures and maintains the dignity of each Indian. Then, my lord, Dr. Ambedkar's decision fraternity. Kindly turn to 601. And as I said, my lord, when the Hindu Code came in 1950, Parliament was not ready. The Hindu Code, my lord, was not only Hindu Marriage Act. It had adoption, success, so many things, my lord. So, my lord, it was not accepted. And Dr. Ambedkar had to resign. Then it came, my lord, in a truncated form. First, my lord, this Hindu Marriage Act, then Succession Act, and the adoption, guardianship, all that, my lord, came separately, not as a part of the Hindu Code bill. So the import is, what was not accepted in 1950 was accepted by Parliament in 56, 58, etc. when it went on. And then became the norm of society. Nobody says today that there is some error in the Hindu Marriage Act. Prior to, my lord, the Hindu Marriage Act, one could marry, my lord, 3 times. A Hindu could marry, have 3 wives. That became, my lord, an anathema when India progressed to the Hindu Marriage Act. That was the law prevailing from the times of the Mughals, the British. So we brought in a new social order. Sorry.
This is the double-edged sword. Because then the argument of the other side is let the parliament do it. And
It's all right, but
Society changes.
point is, Milad. Sometimes, as I said, Milad, the law takes the lead. Sometimes society takes the lead.
Mr. Rotigi, your broad argument there would be that we are talking of constitutional morality. When
My
somebody performs it, that is also constitutional.
That's right. I'm grateful. And Milad, the simple answer is this, to this query being raised again and again. The power, jurisdiction, obligation, and responsibility of this court, Milad, which is cast on this court under the Constitution, is only cast on this court. Even the High Court doesn't have that power. Only this court, as the final protector of fundamental rights and the final arbiter of what the law is and what the Constitution is. 32 is itself a fundamental right. If, my lord, I have a right, and that right is not being, my lord, given its full play, is being clouded or shrouded in some form by the majority, and if I may say so, by the state accepting the majority as correct, I have a right to come to this court, and this court will fail in its duty under the Constitution if, my lord, it does not remedy my right. Say, no, I can't do anything. You wait for Parliament. My lord, there can't be a mandamus to Parliament. I have no voice in Parliament. I have a voice to come to, my lord, open the doors of this court and come here and plead before your lordships. None of us have a right to go anywhere else. Except to, oh, you are a representative in Parliament, you go to your MLA, you tell your MLA, MLA will go there. That's not an answer, my lord, to the Constitution.
the constitutional touchstone only.
I am grateful. That's, my lord, where it stands. And, my lord, this argument has been raised in other cases also. Oh, only 10 or 20 people are affected. Thousands have accepted. Take, my lord, some resolution or some decision of a government. Your lordships have always, my lord, struck down the argument. If one man is affected, he has a right to say that he is affected. If his grievance is valid, then the court will act on it. And that this 100, 200 business was one of the foundations, my lord, in Kaushal. Your lordship may note that. That judgment, my lord, which overruled Nas of this court, which was overruled in Navtej and Puttaswamy, that judgment said, oh, you are a small minority, you are piffling minority,
Minuscule, man.
and 200 prosecutions, what's a big deal? In a country of 100 crore, is minuscule. So, my lord, something like de minimis. Your lordships have a principle of de minimis. If it is so, my lord, inconsequential, the court may not act.
Yeah.
That judgment was founded, my lord, on de minimis. The point is, if one man's fundamental right, my lord, is affected, he has a right to come. And that judgment, therefore, was completely wrong in applying a principle of de minimis on the violation of a fundamental right. Lord, in Shafin Jahan, there is a passage, Lordship Justice Chandrachud, reminding the High Court that you cannot, my lord, go with just, my lord, this majority. I said, my lord, I'll show that.
It's part of current.
No, all right, let me read Ambedkar, Mr. Kirpal wanted me to read. My lord,
Always good to read.
my lord, para 600 at the bottom of that page.
Yes.
Man who faced discrimination
Yeah.
himself.
Yes, of course. My lord, your lordships are aware in London, wherever, my lord, famous people have lived, their names are, my lord, in a blue plaque on a building that here lived, say, X or Y. And one of those houses is where Dr. Ambedkar lived. With that blue plaque, they give the period where so-and-so lived, whether it's a Churchill or whoever it was. That's what Ambedkar. An ideal society should be mobile, should be full of channels for conveying a change taking place in one part to the other parts. In an ideal society, there should be many interests consciously communicated and shared. There should be varied and free points of contact with other modes of association. In other words, there must be social
Osmosis.
endomosis What does that mean? Endo-osmosis. This is the fraternity, which is also another name for democracy. In his address, last address to the Constitutional Assembly, he defined the fraternity as a sense of common brotherhood of all Indians. As in the social and economic plane, Indian society was based on graded inequality. Dr. Ambedkar had warned in clear terms, without fraternity, liberty, and equality cannot become equality cannot not, and therefore is this that way, cannot become a natural course of things. It would require a constable to enforce them. Without fraternity, equality, and liberty, there'll be no deeper than coats of paint. Constitutional morality requires that all citizens need to have a closer look at and understand and imbibe the broad values of the Constitution, which are based on liberty, equality, freedom. Constitutional morality is thus the guiding spirit to achieve transformation, which above all the Constitution seeks to achieve. The acknowledgement carries a necessary implication. The process through which a society matures and imbibes constitutional morality is gradual, perhaps interminably so. Hence, constitutional courts are entrusted with the duty to act as external facilitators. Very important phrase, my lord. To act as an external facilitators and to be a vigilant safeguard against excesses of state power and democratic concentration of power. This court, being the highest constitutional court, has the responsibility to monitor the preservation of constitutional morality as an instrument of fostering conditions for human dignity and liberty to flourish. Popular public morality cannot affect the decisions of this court. I would like to add also, my lord, cannot defer the decisions of this court for the legislative process. Then we'll add 604 on the next page. Invocation of constitutional morality must be seen as an extension of Dr. Ambedkar's formulation of social reform and constitutional transformation, highlighting the significance of individual rights and social terms. He observed, the assertion by the individual of his own opinion and beliefs, his own independence and interest is over, and against group standards, group authorities, and group interests in the beginning of all reform. So, my lord, reform is also a continuous process. Society has gone through a large number of reforms, from widows, from child marriages, from this, that, and the other. Now, my lord, 606. Constitutional morality will impact upon any law which deprives the LGBT individuals of their entitlement to a full and equal citizenship. It's again a reiteration of what I respectfully seek from this court. Nobody can deny, my lord, a full and equal citizenship will be sans marriage, will be sans a family, will be sans the respect of a marriage, and forever to be treated as those two people. After the constitution came into force, no law can be divorced from constitutional morality. Society cannot dictate the expression of sexuality between consenting. This is a private affair. Constitutional morality will supersede any culture or tradition. The interpretation of a right in matter of decriminalization is beyond the determination, so may be determined by the norms. So, my lord, will supersede any culture or tradition. Reference was made to culture or tradition by the other side yesterday. 608. LGBT living under the threat of conformity, grounded in culture, morality have been denied to a basic human existence. They have been stereotyped and prejudiced. Constitutional morality requires this court not to turn a blind eye to their right to an equal participation in citizenship and equal enjoyment of life. Constitutional morality requires that this court must act as a counter-majoritarian institution which discharges the responsibility of protecting constitutional and entrenched rights regardless of what the majority may believe. Constitutional morality must turn into a habit by citizens. I respectfully submit, my lord, it will become a habit only when it is so declared by an authority no less than the Supreme Court on account, my lord, of its moral authority. By respecting the dignity, this court is only fulfilling the foundational promises of our constitution, which is, my lord, way back in 1950. Today we are in 2023. My lord, 613. 613. Now, my lord, 613 will apply equally to the next step, namely marriage. the choice of a partner, the desire for personal intimacy, and yearning to find love and fulfillment in human relationships have a universal appeal, straddling the age and time. In protecting consensual intimacies, the Constitution adopts a simple principle. The state has no business to intrude in these personal matters, nor can societal notions of a heteronormative regulate constitutional liberties based on sexual orientation. Actually, my lord, most of this applies not only to, my lord, decriminalization, applies to our position today. Maybe it had been argued then, maybe it would have been done then, because this is the basis. I am not invoking any new basis, my lord. The basis is already set. It's already the law of the land. But it stopped at decriminalization because that was the issue then. But, my lord, Nalsa, Puttu Swami, and this, and the basis and the groundwork cemented by this court is the groundwork for the declaration which I seek, my lord. I seek no more. I don't seek any extension. It is already here. Everything is here. C615, my lord. Second line. In addressing the LGBT rights, the Constitution speaks as well to the rest of society. In recognizing the rights of LGBT, the Constitution asserts itself as a text for governance about the dominance of sex, which promotes true equality, does so by questioning prevailing notions about the dominant of sexes and gender. In its transformational role, the Constitution directs our attention to resolve the polarities of sex and binary gender. In dealing with these issues, we confront much that polarize our society. Our ability to survive the free will depend whether constitutional values can prevail over the impulse of the time, that is of the current times. Lord, 616. 158 years is too long a period for the LGBT to suffer the indignities of denial that has taken 68 years in after the advent of the Constitution. Is a sobering reminder of the unfinished task which lies ahead. It's also a time to invoke the transformative power of the Constitution. Then we had the declarations in 618. See, we had 618 too. Now it applies equally here today. It doesn't apply or limited only to decriminalization, my lord. See 6182. Members of the community are entitled as all citizens to the full range of constitutional rights, including liberties. The choice of whom to partner, ability to find fulfillment in intimacy, right not to be subject to discriminatory behavior are intrinsic to constitutional protection. This applies equally to marriage. Not restricted, my lord, only to that no case will be filed against you. Point 4, my lord. Members are entitled to the benefit of equal citizenship. This is the broadest phrase. Without discrimination and to the equal protection. I respectfully submit, my lord, these principles apply with equal force today. After a passage of 5 years, these principles are the same even for whatever. Then only one thing, my lord, I wanted to show. Kindly, my lord, turn to 640. This is Justice Indu Malhotra. 640. Actually, my lord, it is similar. Your lordship may note, I don't want to read it. 640, 641. 640.2.4 may be seen, my lord. So, my lord, it's the same thing in paraphrasing in different words because of a different learned judge. 642.4. Sexual orientation is innate. It is an important attribute of one's personality and identity. Homosexuality and bisexuality are natural variants of homosexuality. LGBT have little or no choice over their orientation. This is very important. So it's not, my lord, an elitist concept that I have acquired something today. It is innate. I have little or no choice. LGBT, like other heterosexuals, are entitled to the privacy and the right to lead a dignified existence without fear of persecution. So it's not prosecution only, it is persecution. They are entitled to complete autonomy over the most intimate decisions relating to personal life, including the choice of partners. So, my lord, it will include a sexual act, it will include companionship, it will include marriage, it will include family, it will include walking in public and other spaces. Then we'll have right to privacy 640.3. 640.3.3, Your Lordship may mark placetum E. The right to privacy is not simply the right to be let alone. It has traveled far beyond that. It now incorporates the idea of spatial privacy, decisional privacy, or privacy of choice, extend to the right of fundamental personal choices, including those relating to sexual conduct. So, we have right to make a fundamental personal choice, not limited to sexual conduct, will include, willy-nilly, will include, my lord, marriage. And then, after life, right to health, my lord, your lordship will have, my lord, 644. I wanted to read that note. 644. History owes an apology to the members of this community and their families. So it's not only community, my lord. I emphasize family. Family is also here. For the delay in providing redressal for the ignominy and ostracism that they have suffered through the centuries. The members of this community were compelled to live a life of fear, reprisal, persecution. Account of ignorance of majority would recognize that homosexuality is a complete natural condition, part of a range of human sexuality. The misapplication of the fundamental right of equality guaranteed by 14, infringement, it infringed the fundamental right to non-discrimination under Article 14, etc. And that's how the conclusion.
One para. Just one para.
Lord, I have given your lordship those, I don't want to read now, those 4 cases on the right to marriage. I can give my lord the citations. Shakti Vahini is quoted there already. Shafeen Jahan is also quoted there, my lord. The 2 other ones, your lordship may note, my lord. That's all. So there are 4 of them. Shakti Vahini, under the head of right to marry a person of your own choice. Shakti Vahini and Shafeen Jahan are quoted in Justice Chandrachud's opinion. The 2 others, my lord. One is Deepika. Deepika, my lord, is 2022 SCC Online SC 1088, para 26 to be precise. And Lakshmi, my lord, Lakshmi Bai, Mr. Justice Call, speaking for the court, 2021, 3 SCC, 360, paragraph 11, my lord, to be precise. Now that ends, my lord,
Sorry,
the
Mr.
tracing of the law.
In Deepika saying what para did you specify?
26, my lord.
Para 26. And
Where is the Nepal subsequent judgment?
in Lakshmi Bai.
I've got a copy.
Of Deepika?
Nepal judgment subsequent.
Yeah.
Nepal.
Got it now.
Oh, you got it?
I'll get a printout and give it.
My lord, I'll get a printout and give it to your lordship. Headline. Then Nepal judgment. My lord, your lordship might.
You have given all this in your compilation.
Yes.
You just give the page numbers.
Yes.
That's right.
I'll do that. I'll do
And
that.
the Nepal judgment you can email separately. You can separately email it to the court master.
We'll give it. That's all.
Email it to the court.
Yeah.
Siram,
I'll leave
go
that.
ahead.
Now, my lord, we go to the special marriage act. Kindly see, my lord, section 2, B. My lord, as I had mentioned yesterday, section 2, like all other sections in other acts, starts with unless the context otherwise requires. So, there is elasticity as a measure of a legislative tool to alter the definitions if the context requires, my lord, because no act can look at all the situations which may arise. But I am not restricting my case only on this, because I am saying, my lord, This legislative tool may be good when you are discussing a normal law, but today we are discussing a constitutional provision. And if the constitutional declaration is granted, then all subservient law, all laws are subservient to the constitution. They must then be read in conformity with the constitution. It is on that principle that I am going. Unless the context is, my lord, for normal legislative issues. So now, my lord, please see 2B. Degrees of prohibited relationship. A man and any of the persons mentioned in part 1 and a woman and any person mentioned in part 2 are within the degrees of prohibited relationship. So let's see, my lord, part 1. A man with a person in part 1 will be prohibited. So kindly turn to part 1 of schedule 1 at the end of the act.
So that is in part 2. What parts will apply?
Now let's see part 1. This is all women. So prohibition is that a man will not have a union with all the persons named in part 1, and similarly a woman will not have a relationship and will be prohibited from having a relationship with the males mentioned in part 2. Because it's what, exactly the same thing. Now technically, my lord, father is missing in part 1. I am just posing a question. So a man cannot have a relationship with all those who are named in part 1 who are women. But technically it can include a father. I am only saying technically. Similarly, my lord, in part 2, a woman cannot have any relationship with all the males mentioned in part 2, but technically it includes a mother. My lord, it's not there. It's just a conundrum, my lord. But my lord, if you read it now, the way I am saying, if you read it the way I am saying, Lord, man and woman as a person. So a person and any person mentioned in part 1 and a person mentioned and any person mentioned in part 2
Will apply now.
So both will apply now.
Both parts.
There'll be both cumulative.
Correct.
Club them.
Correct.
You're saying club them. So what you want to read it as, Mr. Rohtgi, as one understands, is a man, instead of a man, any person or any of the persons mentioned in part 1 and 2 of the said schedule. Simple. This is what you're saying.
So according to you, if two men are getting married
So
under the special,
consequently, my lord, once it is person, then 1 and 2 will coalesce and become one. But in fact, it is better reading. If it becomes one, part 1 and part 2 will coalesce into one list. And then
so if it's two men getting married, it's not just part 1 which will apply. Likewise, if two women are getting married,
Correct.
it's not just part 2.
My lord,
according to you.
my lord. It just so happens to fit, my lord, when I was doing this, that's how it fits. See, my lord, for example,
But this is also a tacit indication that the Special Marriage Act didn't contemplate people of the opposite sex getting married, actually. Oh, sorry. I meant same sex.
my lord,
Same sex.
ultimately, my lord,
Yeah.
one can say you're doing violence on the conventional.
It was 1954.
No, one can say you're doing violence by doing all this. But, my lord, if this has to conform to the constitutional declaration, it has to be this. Otherwise, this will become unconstitutional if the declaration is granted. We don't want it to be unconstitutional. We want to utilize it.
Actually, I was telling brother that one of the relation I just saw is sister's daughter.
Yes.
Column 30. But in many communities, in many
Right.
areas, it is almost an intrinsic right to
Right.
There is a proviso.
Custom, yeah.
There is a
So
proviso.
therefore, we are
Section
such a
4D
varied
proviso.
country that
Yes, my lord.
there are
Lordship is right.
cases which are-
There is Section 4D proviso, which talks of where it's
Custom.
permissible under custom.
That is saved.
I was only flagging.
That is
even
saved.
these
Justice Bhatt is right, my lord. If your lordship
very
sees.
difficult. I'm saying it's very difficult to put down in hard words where you have such a varied
Yeah.
norms and customs and
Now, my lord, kindly see section 4.
Very fluid.
Conditions relating to solemnization. Now, 4.1 refers to person. So there is no problem. 4.1a also refers to a spouse. B refers to party, no problem. They are gender neutral. Now see C, my lord. C has males and females. You leave it as it is. If two men are getting married, it is 18. If two female or 21. If two females are getting married, it is 18. You don't need to change it. My lord sees, this is Kohli sees, my lord C.
The whole idea is that you go beyond your.
Yes, yes.
Then again, why?
Why
revert to
male
it
and
there?
female?
See,
Then
then
you are
it
saying
becomes-
person.
You're flitting in and out.
Yes.
When it comes to prohibitions, for one, you revert back to your, and then there are problems when it comes to transgender persons.
Yeah. Yes, 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 yes. Now, my lord, for example,
Then you have to read it like that. Person.
Yeah.
So how would you read?
only thing is, sorry.
How would you read, say, if you were to substitute the word male and female? You would say.
Now, so, my lord, one way to read is a person.
Yes.
If you read it as a person, then it will give a dual age. What will be 18, what will be 21?
Then.
That be the problem. I mean, I don't mind reading it as a person. So it will be a person has completed 21.
No, it can't.
And the person is,
So for the purposes of the main part which you seek a
Yes.
definition of, where it's a person, for the main part.
my lord,
It's a person.
Yes.
Neutral in the sense
right,
that
neutral.
it is gender neutral. But for C, for purposes of C, you have to, you say we will.
So you retain male and female because there are two ages, my lord.
But then you are addressing only.
But you only addressing male and female.
Increase the minimum.
My lord, there is a proposed bill to increase 18 to 21.
Right.
There is already a bill because they find that 18 is also too low.
Right.
For child, my lord, marriages, 18 is also too low. So they want to make it 21. The moment 18 becomes 21 for women,
That's a slightly dangerous argument. Then.
no, I'm only indicating. My lord, it's not an argument.
In fact, interestingly, before just Narsma and me, this part that the female shall be the age of 18 years was challenged by Mr. Ashwini Upadhyay.
Yeah.
And we dismissed the petition saying that if we hold that that part is unconstitutional, there'll be no minimum age of marriage for women at all. A 4-year-old girl can then get married. So we said, therefore, look, we'll not.
Your lordship may read it up.
Ashwini came here.
So
Remember?
this is the second. Does it impact? How does it impact those who are of heterosexual couple? Because then you will be looking at this interpretation in a different.
Yes, yes, absolutely right. Because we can't forget the heterosexual group.
That's right.
Because they can also get married. So we can't forget it. So keep that and keep it as it is.
No, then in that case, what you're saying is for sex relationship, this is the person. For heterosexual couples, for heterosexual,
Yes.
this is part 1 and part 2 apply.
Right.
That is one more.
That is one way. Yes. Yes.
One way. That is.
No, correct, correct. So your lordship is right. Keeping the distinction in mind for the heterosexual and for, my lord, this.
And then there's a third way, which is for a same-sex male couple,
Yeah.
it will be 21. For a
And same-sex female couple will be 18.
would be 18.
Will be 18.
I don't know.
That you
Do
deal.
it exactly for the transgenders.
I,
Is to make everything as 21 for purposes
yeah,
of.
no problem. We have no problem.
Then if
Now see, my lord, 12.
by,
Sorry. One, please.
if you go by the act which
Yes.
Sir pointed out
Yes.
yesterday,
Yes.
there are so many other spectrum varieties. How do they get accommodated? When you look at them, how do they get accommodated? Work that out, because
Milord, Milord, they want to deal with that. Otherwise, Milord, I will cover all the fields.
Section 4 guarantees them, my lord, the option to choose gender they manifest. My lord, a male will manifest as.
So ultimately, you're going back to the social stereotype which you want to avoid.
My lord, that is because we are maintaining
No,
equality.
not a question of because.
The minimum is 18, it should not be 21.
One
it should
second,
be
my lord is saying
21.
something. My lord is saying.
No, I understand. So ultimately, you say you go back there, but for here it is this, and for normal who are heterosexual couples, it is whatever they are. So this interpretation has to be threefold for this enactment.
No, it syncs with, my lord, section 4 only says.
It syncs with what you want. It suits your purpose.
No, no,
The court has to.
my lord, the act guarantees the manifested gender, my lord. Act guarantees the manifested gender.
All right, we'll
Milord, may see that.
yes.
Because the transgender will have to fall in one or the other, Milord, for that purpose.
Anyway, you're breaking
Milord,
up
should
the
we see that?
submission, so we'll hear Mr.
We'll address
Vishwanathan
that.
on that.
Yeah. Now, Milord, see 12, for example. 12. Place and form of solemnization. Now, Milord, 12.1 talks about parties. 12.2 talks about parties. Now, look at the oath. The last line. I, A, take thee, B, to be my lawful wife or husband. You replace it with spouse. You replace it with spouse. That's it. I take you as a spouse.
27.
Will not kindly turn to 27. No, see 22. 22. Restitution. Restitution, Lord, here also it is husband or wife. Read spouse. Because the third line is aggrieved party. And the explanation is person. So they are neutral anyway. 23 is the same position, Lord, for judicial separation. See 27. Here also, my lord, divorce can be by either party, husband or wife. So you have to read spouse. See, my lord, 1 capital A. A wife may also present. So a spouse.
Expanded then.
That's all.
Six into this.
Then, my lord, 36, 37. Now, this is the right, my lord, only to women. 36 and 37. Actually, my lord, apart from anything else, so many years have gone by that this would be otherwise unconstitutional today. To say that only, my lord, a husband will pay to the wife. Today, in maintenance, under the Hindu Marriage Act, it's either way. It's either way, my lord. If the wife is earning much more, the husband is not earning, the wife will pay.
That's right.
This is earlier mindset. Actually speaking, it will be unconstitutional today to say, my lord, only one spouse in the marriage will pay on the premise that the husband is the bread earner and the wife is not. So actually 36 and 37 will suffer from that problem. So read it as spouse, give the right to both, not only here, but there also.
I was just.
So, my lord, which will affect, my lord, the rights somewhere else.
Because it's
So-
only, it is only for us that it is
It's
unconstitutional.
only for us.
That is unconstitutional.
Yes, possibly. Yes, yes, yes.
So it has to
This is what I was.
Yes, yes.
How do you deal with this 27(1)?
be spouse.
No, suppose your lordship reads the spouse, 27(1)(a).
Sodomy and bestiality is not.
Problem is bestiality also in it. Huh. Hmm? All right, you. My friend, Lord, wants to say something on that, Lord, let him deal with it. Lord, I want to finish, Lord. I am done, whatever it is. And I am grateful, Lord. My friends will take it forward.
Your Lordship may take it, Willis, that I've heard very carefully the sequence, the preliminary objection part, what my learned friend has argued. 95% will not be repeated, Willis. There'll be some slight overlap here and there. Your Lordship may not get the answer in the immediate sequence your Lordship wants, but I'm going to be dealing with all of it, Willis. Your Lordship may rest assured. And I'll have, Willis, broadly 3 heads of submissions, which will carry me till tomorrow. But, Willis, may I just tell your Lordships?
How long? What's the time?
Well, I was hoping to do substantially today, but I'm now starting late. Willis, tomorrow, sometime pre-lunch or just at lunch.
It can't be just too much.
Well,
It up today.
today,
Your abilities to put it in point-wise form,
no, well,
I think should finish it much before today, I thought.
I'll tell you, Lordship, today. That may not be so, Willis, despite the best of my abilities or lack of them, Willis. Tell Lordship, this is a matter of some moment. I am not repeating. I'm giving your Lordship, Willis, facets which are important. But Willis, I'll be going in a...
You can go to 7thly, 8thly, we'll go.
Well,
7 or 8 submissions.
Pointillism is a virtue which your Lordship is putting against me, Willis. I thought, Willis, I was
We are
getting a
appreciating
virtue.
your virtue and asking you to stand by your virtue.
Singhvi, from the T20 or one-day international, we have gone into the test.
This is at least between a one day and a test, if not a test. Your Lordship will find it, let it flow, Willis. I'll not repeat, I won't take your Lordship's time. Maybe there's a slight overlap tomorrow, but today it might not be possible. I wish I had started earlier, but my learned friend had other issues to deal with
today. Yeah.
Now, can I?
Dr. Singhvi, you will have to...
Today we'll...
See, these matters, you have experiences of more than this country, I keep repeating. Nowhere I say in the world will arguments proceed in a manner where there's some kind of an infinite time.
Your Lordship,
I think courts are liberal. Whatever, maybe matter of the moment, maybe the most crucial issue, maybe the most issue important for the country. But I don't think time frames can spill over.
Some matters, Willis, are evolving. They evolve, Willis, as you argue, and more importantly, as your Lordship asks questions, which is very important to make the matter evolve.
If you don't make us be quiet.
No, I'm saying, Willis, it's more important to make it evolve.
No, I'm saying, therefore, if it is a presumption that our intersections, interventions cause the problem.
No, Willis, I'm saying just the opposite.
Therefore, it's absolutely to my mind, I'm very clear, it's absolutely the outer limit for today.
Are there any written submissions that have been?
We have, Willis, we have. Let us see, Willis, how it progresses.
I'm confident you will be able to do it.
Dr. Singhvi, I'm sure there's something which can go from the bench to the bar, which is that, sometimes you feel that merely because you had longer time to decide a matter doesn't mean that you decided it better.
No.
Because
the Lordship will see how much.
Sometimes because you had a longer time, you might have forgotten something also as well. So likewise for the bar as well, merely because you have a longer time doesn't mean that you put it across better.
If my chief was not presiding, I was only there, I would just say my attention span doesn't last this long.
Now, well, it's
any argument.
I'll remind my learned friend next time, when he seeks time for Lordships.
No.
When he seeks time
we have done it. I have done it. Remember in the arbitration matter.
Arbitration, you did that.
You know that I did that.
I have a remedy of curtailing.
That's not true at all.
Which I will not share, my lord.
Anyway, Malas, I think...
I have a remedy of curtailing his arguments today, my lord.
Anyway.
I am only saying that all of us, and I include us also as part of it, have to get used to finishing with whatever matter in a time-bound manner, because there are other matters waiting for it to be heard.
Well, all I can say is, because I've had the privilege of doing the last continuous 5 constitutional benches here, Lordship would not have found me taking extra time in any of those.
Yes.
And Lordship, rest assured, back to back, Palas.
All right.
Rest assured, it won't happen again. But Palas, what is there I need to, Palas, put before Lordship.
I'm sure I'm confident we'll make you finish.
Yes. But Palas, what is there, Palas, I don't want to truncate to a fault.
Sybil was on that side with him. Right?
Yes. Now, this matter is...
You said you're making 3 points, right? Three submissions you said when we...
No, those 3 headings, before I come to the 3 headings, let me just open by saying, what is this matter about? Well, it is, of course, about those three headings, which are, well, first and foremost, the interpretation of the Special Marriage Act to be interpreted what might be called constitution compliant, consistent with the Constitution, on the touchstone of, well, the larger constitutional values of preamble and all the Part 3 relevant articles. So that is constitutional compliant interpretation. And that brings in 21, 19. The operative word is non-discriminatory or a discriminatory exclusion or achieving a non-discriminatory inclusion. That's the most important catchword in this case. That is the first head. The second head, Malas, is going to be the notice and objections regime of the same act. And the third would be, Malas, the relief, which your lordship will modulate or tailor or, Malas, mold in whatever appropriate form your lordship wants.
On the second point, is there, I take it that there is a petition asking for a declaration?
Yes, in particular, my petition.
No,
Directly, there are more also.
No,
There are
it's all
several.
right. I just
So
want.
long as there's so long as there's a prayer, then there's no.
My learned friend was told, well, rightly that there are other
Well.
matters pending, but he said this is unique
All
to
right.
this point.
And what is the third point you were saying?
Third is remedies. Well, how you
Remedies.
mold or tailor the remedies or achieve a result which is effective, Malas, on the ground. Before I go by these three heads, Willis, the first question I ask myself, what is this case about? And a very brief opening, Willis. My submission is, Willis, that the heart of this case is not about the statutory provision, the reading of these sections as constitution compliant or non-compliant, which are important, the notice and objection regime. The heart of this case is, Willis, the right to choose. The most enduring of all relationships, the marital relationship, regardless of sex and sexual orientation. Regardless of gender or gender identity. And Malus, to manifest the idea of love in marriage, regardless of those distinctions, sex, sexual orientation, gender identity. The right to love, the right to manifest that love in the form of marriage, regardless of these identities, is the heart of this case. And the obverse heart of this case is the discriminatory denial to a section. The mirror image part of this case is the discriminatory denial to a section of the community to do it based on that sex, sexual orientation, gender or gender identity. That's the exclusion. That's the discrimination. Right. Whereas Navte Johar was momentous by decriminalization. But it still remains, Wallace, in a real sense, little done, vast undone. And your lordship is now traveling from the little done in the journey of the vast undone. Your lordship is trying to do the significant done. There'll always be, of course, things left. So your lordship is removing the next brick of discrimination and exclusion. Exclusion and discrimination is the heart of that issue. Your Lordship has dealt with anti-discrimination as the underlying philosophy of Navtej Johar. Your Lordship is now knitting a more seamless web, if Your Lordship agrees with this side, of anti-discrimination. On several other facets, that was, in that sense, a relatively small patch. And the other facet of this case at the outset is the recognition that it is not the state alone which threatens these core constitutional values. It is not the state alone which imperils the core values of equality, liberty, fraternity. It is also groups, private groups, non-state actors. It's used in a different context, non-state actors, but it applies here as well. Which are called entrenched and encrusted forces over the years, whether in society or as a constitutional thing. They also
could be even new forms of organization.
New forms of organization. They also need these groups which are here on this side need protection from those entrenched and encrusted forms also. I'm not calling them villains, but I'm saying from a certain entrenched thinking process which can be as invasive of those core values as state action. That's the point I'm making. They can be an R, and therefore, Your Lordship will be dealing with striking by protecting those vulnerable sections from both those facets, state and non-state.
What could be an example of that?
One obvious example would be the notice and objections regime. One obvious example. Immediate reaction, but there are many more. I mean, one obvious example is notice and objections regime.
So that argument prevails.
Yeah.
That argument prevails for that provision.
But I'll be giving more examples as I go along, because vigilante groups.
No, the point is social processes being what they are.
Yes.
A declaration of marriage or even the kind of relief that you seek, how will that per se result in your protection? You will, of course, that 7 issue perhaps is the easiest way out.
No,
but otherwise, the protection that you seek would want us to give a far wider declaration.
Now, assume Your Lordship were to hold that same person marriage. I'm not giving into the consequences, is valid. The validation, the legalization of same-sex or same-person marriage is, along with necessary consequences, a very big victory. Your Lordship is not able to eliminate murder. But Your Lordship has said murder in law is wrong. When Your Lordship says murder in law is right, or in this case, something else is right, that is the protection. Once Your Lordship protects me by declaration, I am on the right side of the law.
You're in the right side of the law for no difficulty. But those groups will continue to operate the way they are, unless what you are saying is the value of this right is such that the state is under an obligation to protect you.
Absolutely. No, and that's it. Once Your Lordship.
It's not a mere declaration. We have asked specifically in our protocol.
I am going further. It's not a small. Let us for a minute assume Your Lordship doesn't do what he's asking. I'm all for him. Let's assume Your Lordship doesn't do what he's asking.
The value that you place to fundamental rights.
Yes.
One takes it is the same value. It's an indivisible value.
Yes.
Right to free speech, for instance.
Yes.
Right to association, and all those rights. You can't privilege one over the other.
Correct.
You can't privilege one over the other. Then what you're saying today is you are wanting us to strike another path and say that all these, or at least start with, you give this privilege this and give this right to us, which the state is bound to, provide and protect us.
No, I am not asking for any new right. First of all, I'm not using a Hoffeldian rights positive obligation.
Talking of, saying that you are asking. if that's the argument,
Yes.
now in that sense, there'll be, I mean, we'll be asking the state to do nothing wrong in it. The state is bound to protect it.
Let me very straight away answer that.
Exercise of free speech, for instance, the state plays a role.
Absolutely, Manas. Now, Manas, for a minute, let us not. I do not want to minimize the great advance your Lordship would be doing by merely giving the declaration without even the very important point my learned friend is making. For a minute, I'm testing it by answering your Lordship by testing it. Your Lordship, Manas, assume, Manas, that your Lordship puts you on the right side of the law with consequential, Manas, directions. Manas, the first and foremost consequence of that is that I am entitled to, Manas, seek, ensure, and Manas, demand as a matter of right state protection for an invasion of what is declared as a valid thing, even without this.
Just sorry, one last question to play the devil's advocate.
Yes, yes.
What prevents the state from protecting you today? Because it is decriminalized.
Decriminalization is a very small part. It doesn't give me any of the rights I can demand, Manas, once I'm in a marriage. Once I'm in a marriage, that it doesn't give me.
Come back after lunch.
Get into these nuances, otherwise
Yes, Dr. Singh.
So, Malas, I will first deal with the larger constitutional facets on non-discrimination, dignity, and free speech. And then I will give a lot of very interesting Malas, development on the approach to interpretation to make things constitutional compliant in this country and in England, Malas, to make them treaty compliant. And that is a very interesting new development which will answer your Lordship's query. And then I will come to Malas, the reconciliation which Justice Bhatt mentioned about. It will be much better to do it in that sequence. Exactly the reconciliation of wanting to choose what you want here also and there also, and the inconsistency, if any, it will Malas fit in there. So let me proceed in that way. So Malas, on the larger picture, as I said, these are the three constitutional facets being practiced on ascriptive issues. Ascriptive issues are those which are not taken by choice, which are largely involuntary. So if there is discrimination or a violation of dignity or a violation of the larger concept of free expression, it is based on ascriptive issues. Ascriptive characteristics is a better word. Race, caste, ethnicity, national origin. Here it would be Malas, sex or sexual orientation. And according to us, the implied exclusion of the entire LGBTQ class from SMA is based on a sole marker of identity, sex and sexual orientation. So the conceptual point is that the implied exclusion, because according to us, there's no exclusion explicitly, the implied exclusion of LGBT class is based on a sole ascriptive characteristic, namely sex or sexual orientation as a marker of identity, as it could be, for example, origin or race, etc., which is not an issue here. The second aspect here, in the larger constitutional perspective, is that, brothers, when the government of India, in its various places on the counter, and I'll read one line only, says, for example, socially, culturally, and legally ingrained into the idea and concept of marriage, the traditional marriage forms. Because it fails to really address that the SMA was created by your lordship, I mean by the legislature, as an alternative to what you might call socially, culturally, legally ingrained concepts of marriage. The very creation of SMA was that. To include what might be called, and I use a loose phrase, not quite right to use it, but that's the real way to use it, unpopular marriages, interfaith marriages, socially sanctioned marriages, directly or indirectly. Unless you had them in mind, the socially sanctioned marriages in a negative sense, why would you create a SMA? So, Manas, the government of India is actually hoist on its own petard when it says that we will look only at a particular format of marriage, but you have got Manas SMA for decades. Actually, if you dig deep, the government of India is saying really that you are liable to be excluded, Mr. Singhvi, only because of the ascriptive characteristic, involuntarily, externally, and not by choice. Now, Malas, there is this phrase, hoist on your own petard, which Malas applies in a very delightful way here. Because what does the government here say? It says marriage is a vital institution, we must protect it. Then they say, we've got all the extracts from the counter. It is something which lies at the heart of society, and your lordship is really attacking the base of society. If being asked even to read in different forms of marriage, etc., etc. Well, it's why I use the word hoist on the own petard. In para 15 of my written submission, I have in fact said that it is because marriage is a vital foundation that we, the excluded class, wants to have all those indicia or index of marriage which follow a marriage. Namely, why is marriage important, Malas? Why is it that there is one class of marriage, I will use the word traditional marriage, versus the other excluded class, non-traditional? Let's use just a neutral phrase. Reason number one, for those who seek any form of marriage, whether this side or that side, they seek it, Malas, for a community and a social validation of a relationship. And I can't agree more with Mr. Tushar Mehta that just like heterosexuals seek it and deserve it, non-heterosexuals seek it and also deserve it. Number two, marriage is vital and important because of a sense of security it provides to couples. Of course, it applies much more to vulnerable couples, which your Lordship is already protecting under SMA. And this is another set of vulnerable couples this side. But it applies as a sense of security to couples generally. And why should there be an exclusion of one set of couples for that as opposed to another set? So Alan is absolutely right. It's because of the importance of the institution of marriage that we wanted to apply across the board, across this table, not that it stops in between this table. Third, it provides Willis greater financial support / security. And not one of these, if it applies to heterosexual couples, should not Willis travel on to the non-heterosexual class. Not one of these. Based on an ascriptive disqualification. Number 4, which I must put in a chart now. I made an appendix, which you should find useful. What my Lord put as consequences. That's the 4th point. It's a gateway to those consequences. I mean, obviously, I don't marry because I want a tax benefit. I mean, some people do, but some people do. But well, normally, I mean, you would not be. But well, it is a gateway to 10 important things there.
People even separate to get tax benefit.
Yes.
What I was going to say.
That actually is more likely.
It's very common.
More likely, or pretend to separate as the case may be. But Malas, those gateways are tax, inheritance, adoption. Take Malas, most important is adoption. Your Lordships has in this court, Malas, well before we started talking about Malas, ascriptive cases like this, many years or decades, several colleagues of ours, Malas, who may be single persons, who have adopted. We know it, Malas. We have been in the bar. Your Lordship has been in the bar.
Incidentally, even if a couple is in a gay relationship or a lesbian relationship, one of them can still adopt.
No, Manas, more.
So the whole argument that this will create a sort of a psychological impact on the child is belied by the fact that even today, on the state of the law as it stands,
grateful.
Once you have decriminalized homosexuality,
absolutely,
therefore it's open to people to live in together, and one of you can adopt. It's just that the child loses the benefit of parenthood, so to speak, of both
with the respect. If your Lordship were to look around practically on the ground, this is one of the most important reasons, which is fifth, is that marriage by itself, or rather, Lordship we call it marital status. Marital status is by itself, a source of dignity, fulfillment, and self-respect. These are not mere adjectives, this is a real life, real world. It does happen, it is actually happening, it is vital. And a lot of people are acting for that basis. It's a source of dignity, fulfillment, and self-respect as a core member of society. And last is, it's a integral aspect of the ability to have and enjoy a family life. To have and enjoy a family life. With the other indicia we have talked about. Your Lordship, a cross-reference in brackets, para 15 of my WS has these. Just, I'll come to it later, just cross-reference it on the side, para 15. Now, if I may digress here for 30 seconds only, just turn to Appendix 1 of my written submission at page 30 of my written submissions, which is a useful listing. This is a bit of a digression, it's useful listing.
Part of what?
453
Compilation 1.
of the written submission volume. Apparently, Your Lordship, in your soft copies have written submission sets all together. In that set, I am 453.
We go to volume 1 of the compilation?
Volume, yes, volume 1, page 453. It starts, right?
Got it. Number 7. Page 4.
Yes, your number
Sorry,
7.
appendix is at page 453.
Number 7.
It starts at 424. My appendix is at 453.
453.
Index volume 1. ये volume 1 होगा ना?
Compilation 1.
volume 1 है.
Compilation 1. Not volume 1.
File for the bench is called compilation 1.
I'm told, the file for Your Lordships is called compilation 1.
Yes, compilation.
Correct. Some 900 odd pages. Yes. These are the laws.
Which para you want us to read?
Now, let's just go to page 453 of my written submission, just the appendix.
Appendix 1.
Yeah, appendix 1, correct. I made it vertical rights and horizontal rights. It doesn't really matter so much for the time being, but vertical rights are more against the state or involving the state. And horizontal rights are non-state groupings. Justice Call has got 453.
Only 1 second.
Yes.
Now,
Where do you want us?
It's at page 32. So it will be PDF page 453.
When I
456.
When I intervened yesterday to say
456, 456, sorry.
Of this
Print page 453.
Yeah. Appendix 1, no?
Yeah, appendix 1.
When I intervened yesterday to say that Your Lordship is not hearing just the word marriage or a concept of marriage, just kind of a label given, but a meaningful
Content.
meaningful concept with content. This call doesn't have it. Got it? When I said yesterday, that Your Lordship is not dealing with an abstract concept of marriage as a label to be put on my head, without content, without meaningful consequence, this is the meaning. One category I've given 5-6 points in my para 15. I just gave it to Your Lordship orally, which is the more societal aspect. These are the more concrete aspects. And which of these is deniable merely because I am not that side of the table, but I am the other category of couple. Adoption, surrogacy, intestate succession, tax exemption, tax deductions. It simply requires marriage. That's all. Compassionate government appointments. And this is, of course, only illustrative. I don't claim it to be exhaustive. This is illustrative, but this is a useful list. We are not talking of anything else. Only marriage is required. Everything else follows. Compensation to dependents, appointment of nominee for receipt of post-retirement benefits. Privilege is an interesting one, spousal communication, 123 is now largely forgotten. 122, I'm sorry. Right to bodily remains. And so on and so forth. There is the next page, which is the horizontal set. which are more daily incidents of harassment, if I may use that phrase.
There's one interesting question here. We
Yes.
talk of, for instance, insurance. Now, the insurance law per se, do we have any
That is
idea?
item 1 in the horizontal side. Yes.
Number 1.
Yes.
Family insurance.
Yes.
Medical also, I assume.
Renting homes,
So
opening
these
bank accounts.
These are subject to regulations.
Yes.
So IRDA, do we have IRDA regulations, or these are standard policies which are approved?
I have not given a lordship the individuated thing. They would originate from an IRDA requirement, but they will be all in all the policies.
No, I agree. I'm saying that those IRDA regulations, do they use these expressions, or are they left loose?
I'll have the specific regulation checked
I
up.
suspect they're
Insurance.
open-ended. They're open-ended because you could nominate someone who is not your family member. One, we are not looking at a nomination. We are looking at a default situation. For
I'm
instance,
talking of a
somebody-
group. Actually, this is copying of group insurance. Your lordship is right. Nomination can be anybody in the family, or in
Anyone
fact, even
outside.
non-family also. But we are talking about group insurance. I'm a family, 1, 2, and children. Then you get a family group insurance. There you may not get. I will give your lordship the exact regulation if any, just make a note of it. But the group will not be available without the marriage
So
format.
this is not, in that sense, totally horizontal. It is dependent on those regulations, right?
Very well.
Yes.
This may partake a little bit of this and that other also. Your lordship is right. But I have a feeling that
Likewise, you see, we come to joint bank accounts. You have the banking regulations.
maybe some RPI regulations,
So
maybe.
they will also have these regulations or laws.
But my lord is right. I mean, that could be a overlap. But
You're looking at 2 steps beyond that.
I am saying, Muluz, at the end of the day, the basis of denying me is that I am not married. Or that I am married in a form not accepted by law. That's about it. That's the bottom line. But please give me also the insurance and the
You
other thing
see,
also.
the point is,
Yes.
there are certain things which can be perhaps done straight away.
Yes.
Without entering the other arenas.
Yes.
Those are perhaps segregable. This is a open thought that if there is no prohibition or provision in the parent enactment, it becomes that much easier.
Well, my lord is right. That may require a more detailed nitty-gritty segregation. My lord is right. For example, policies have it or not, but I will do that to the extent we can. My learned friends will help us, Malus, to give us. But just the recognition of marital status will be a very great advance in any case. That's the first point.
May I just answer that? Insurance. Principle that is applied is just that of marriage. Now, how my lords defines marriage will address those concerns immediately. So any bank, there is no specific RBI guideline on who can. The assumption there is if you are spouses, you can have that joint bank account. Similarly for insurance as well.
This is where, this is where Mr. Guruswamy, if you go back to some of the older case,
Yes,
if you remember that consumer
Make note of both.
LIC,
yes, ma'am.
Insurance.
the court actually gave a direction, 1995, Justice Ramaswamy's judgment. So there are certain things which can be done straight away without much, barrier,
Yes, ma'am.
without having to overcome barriers. So that is what you have to identify and tell us.
We'll add that. What my lord is saying is there may be something which may have no barrier at all.
In this, my lord, I suspect that the moment the court opens up the definition of marriage, those concerns are addressed because routinely insurance companies and banks have only this concern.
You have to be married.
That's-
Spousal, that's all.
And that will be.
But that's the baseline, Malus. In any case, that baseline is there. Whatever addition your lordship has is. By saying, I will give your lordship 2 illustrative examples of bank accounts and insurance. saying only this, that we will give your lordship two illustrative examples of the minutiae for family insurance and bank, but the baseline requirement of marriage is the crucial point, my lords, which your lordship is at the moment from our side focusing on. Now, my lords, of these three headings, the most important is discriminatory exclusion in the constitutional context. The first one, discriminatory exclusion of this class on only sex and sexual orientation. Which is, I've said, an ascriptive characteristic. Now, Navtej has been read in great detail. I have taken notes, fellows, and instructed also to say that 3 paras have not been read, and I'll only want those 3 paras to be underlined. Very sure. Your lordships are more suspicious of and more inclined to interfere when Miller's classifications of disadvantage based on sex or gender are involved facially. That's the principle of Navtej, also which has not been read. Just come to 316 para number. Firstly, at page 9, at page 165 of the SCC, 947 of your lordship's PDF. Volume 1 PDF, your lordship is marked Navtej in great detail. 947, para 316. Well, amongst ascriptive conditions, where the ascriptive condition. Seven? 947.
Para? 947.
You go to that box, Sanjay.
Yes, para 316.
Just 1 second. Go after 7.
This is the same page of the same Navtej your lordship has been marking.
2, 3.
Delete the whole thing and now type 947.
316.
316.
Even amongst ascriptive conditions, your 947 para 316.
978. Sorry, it's PDF is 978.
That's a PDF page.
Not both, you have to give the one they are using. You give me not both, give me what they are using.
978.
Return. Yeah.
Yeah. So, well, even amongst ascriptive conditions, your lordship will look more suspiciously at those based on gender and sex. Just come to 316. The learned judges then went on to further hold that the standard of judicial scrutiny. Now we are on the standard of judicial scrutiny, on the approach, which on their face effect discrimination is as follows. It is borne in mind that legislation pronounced protective discrimination aims such as this one potentially serve as double-edged swords. I read the italicized portion, Mullahs. Legislation should not only be assessed on its proposed aims, but rather on the implications of the effects. The impugned legislation suffers from incurable fixations of stereotype, morality, and conception of sexual role. The perspective thus arrived at is outmoded in content and stifling in means. Now, I'm interested in the next parameters. No law in its ultimate effect should end up perpetuating the oppression of women. Personal freedom is a fundamental tenet which cannot be compromised in the name of expediency unless there is compelling state purpose. This is the last sentence, heightened level of security is the normative threshold for judicial review in scrutiny in such cases. And then, Malads, Which is 1079, the correct page for them. 1110, page number, para 637.3. PDF pages 1110. We are giving only PDF number. Now PDF. Well, it's the whole para is important, but to save time, I won't read the whole. It talks of 377 criminalization of all forms of non-penile vaginal intercourse, etc. Come to the last 4 lines of 637.3. The natural or innate sexual orientation of a person.
Which para are you reading?
Whereas I'm reading 1110 is the PDF page, para is 637.3.
Yes.
The last part, just scholars got, of that para, 637.3. The end. The natural or innate sexual orientation of a person cannot be a ground for discrimination, where a legislation discriminates on the basis of an intrinsic and core trait.
This is Justice Indu Malhotra.
I beg pardon? Yes, Justice Malhotra, that's correct. I'm sorry. That's the ascriptive. The word ascriptive is not used exactly ascriptive.
Yes, yes.
Core trait of an individual cannot form a reasonable classification based on individual intelligible differentia. Then one para after next page, point 5. A person's sexual orientation is intrinsic to their being. It is connected with their individuality and identity. A classification which discriminates between persons on their innate nature, that's ascriptive. That's the meaning of ascriptive. Would be violative of their fundamental rights and cannot withstand the test of constitutional morality.
Principle is actually very simple, that you cannot discriminate against, the state cannot discriminate against an individual on the basis of a characteristic over which the person has no control.
Exactly. That's, if I may say so, very pithily and very simply put. That's the essence of it. But you are also now to apply it, traveling away from criminalization to a general principle also it applies. How can it be that criminalization doesn't apply elsewhere? Then,
and when you say that, this is an innate characteristic, it's also an argument in response to the contention that this is very, elitist, or it's urban, or it has a certain class bias. Something which is innate can't have a class bias.
As a matter of fact, it can never be a bias because it's not in any form acquired.
It may be more urban in its manifestations because more people in urban areas are coming out of the closed closet.
But in smaller town, India is no more only that rural urban. We have this nice word rurban. We have a very big swathe of Indian territory and population which is rurban.
And maybe there's no data is coming out by the government to indicate that this is urban or anything like that.
Nothing.
No data at all.
One of the points we are making is that every government in the counter is without the single survey, single data, single test. Not one. I've made that point repeatedly in my written submissions.
Both innate and autonomy to choose.
You may be having data.
Just on this, my client was forced to go to the streets, Zainab Patel, transgender, disowned by the family, begged on the streets, came up on her own, and today she is director in KPMG, all by herself. To be branded urban elitist, shows absolute lack of grace. Union should have shown a little more grace in the count. Begged on the streets, on her own, came up. Today she is member of the Transgender Council nominated by the government under the Act.
And similarly, my lords, in my petition, Akkai Padmashalu, she's a well-known trans activist. At the age of 15, she was thrown out of her house. She had to drop out of school. She was on the streets. And thereafter, my lords, she has come back to the mainstream. And my lords, this is the lives they have to lead. To say that they are elitist, these are totally poor working class backgrounds people have come from. And to say that this is an elitist concern, my lords, is
20 villages may have pardon.
They need to. In fact, under the Transgender Act of this union itself, Kinnars, Aravans, Jogtis, and Hinjras are recognized as specific categories.
Named by category, actually, in the
Categorized.
definition, we saw it yesterday.
Manoj, these are not urban for the government.
Now, therefore, please ask a simple question. Are you really filing? I'm very sorry.
Yes, Doctor.
Your Lordship will now come to us by written submission, para.
Can we just get back to you a little later so that
Yes,
that way
bring
Dr. Singhvi's flow is, yeah, we'll complete with Dr.
Because,
Singhvi's argument.
page, my written submissions will start at 427. Your Lordship has the compilation,
Yes.
only submissions. In that PDF page is
Yes,
427. Come to Ballas 433, or rather 432, where para 19 is there. Para 19, 432. Of my submissions.
Volume 1, you get to go to compilation 1 now. Click on compilation 1. Just click on the last.
460 with a high.
You have to, okay, you can just scroll down. So it'll take a second.
He was
19. In any event, petitioners submit that the exclusion fails the test of 14. While there does exist an intelligible differentia, which is sexual orientation, it cannot possibly have any rational nexus. Now come to 20. First, it is important to reiterate that in its origin and evolution, SMA is an avowedly secular law, which was meant to serve as an alternative for individuals who could not or did not want to solemnize marriages under applicable personal religious law. My Lord is so said in para 15 and 19 of that judgment, Neha. Now, this SOR is important. As per the SOR of the SMA, the Act was passed to, quote, provide a special form of marriage which can be taken advantage of by any person in India and by all Indian nationals in foreign countries, irrespective of the faith which either party to the marriage may profess. Consequently, and I'm not concerned with Hindu Marriage Act, I wish them good luck. They have several other important points on their side. I'm not treading on their path, but I'm just saying, in contrast to the HMA, where the conditions must comply with Hindu religion, the SMA is an irreligious or non-religious marriage-related legislation. This addresses a point that the respondent repeatedly makes in its counter affidavit. What is this main point, Manus? Cultural understanding of marriage as a union. Cultural understanding of marriage was not the basis of the SMA.
So what you're saying is that the SMA was basically intended to be agnostic to faith.
Exactly.
So by reading it as agnostic to sexual orientation, you're not making a leap of faith.
Leap of faith.
On the same.
Very grateful. That's a pithy summary. What is Balas also religion is very heavily imbued with culture. If it is, as Rashi puts it, agnostic to faith, it is also largely agnostic to cultural situations. It cannot be divorced. Secondly, Malas, just pause here for a minute before I go to the later part. Broadly, the government of India is saying what? I mean, look at with great respect to the kind of stand. Stand 1, cultural ethos, we've dealt with. Stand 2, which I am very strongly supporting, marriage is a vital institution. I say so, I give in my para 15 those 6 reasons, and in my appendix the several important secular consequences. Third reason, that it will impact personal law, which your Lordship has now put on a separate side. Now, the fourth reason is important and interesting. It is what is known as self-referential or self-validating statements. What is self-reference? What they are saying is, since I, the government of India, have defined marriage as a union between man and woman, therefore, by definition, you are wrong and illegal. Well, this your Lordship has said is an example of self-validating reasoning or self-referential reasoning. In constitutional terms, it actually equates classification with legislative purpose in Article 14 terms. It conflates the two.
Where have you formulated it so we can read it and then
Yes.
you can make your submission?
Well, this is 22 and 23.
Let's just read that.
22. Secondly, the respondent cannot argue, as it does in para 23, his counter para 23, that it has simply defined marriage as a union between a man and a woman, and that constitutes legislative policy. That would be circular and self-referential reasoning, which does nothing more than, this is important, equate the classification with the purpose. This obviously cannot be a valid defense to an Article 14 challenge, as in effect, any legislative classification can pass Article 14 scrutiny by the state simply declaring that the classification itself is the purpose. Let us see an example, Balas. As an example, one can imagine the state announcing a welfare benefit that it then declares off limits for blue-eyed people. On being challenged, the state simply says, that it has defined the welfare benefit as one that all persons except blue-eyed people are eligible for, and that the legislative purpose is to exclude blue-eyed people from accessing. It is submitted, this is self-referential to decide whether exclusion of blue-eyed is valid or not that I say that blue-eyed are out. You have to decide the validity of blue-eyed being out. That itself may be wrong or right. But
obviously, the basis of the classification cannot be conflated with the purpose of the classification.
They can't be conflated, which is what is happening here, unfortunately. Well, as one example where my lords dealt with this situation was Deepak Sibbal's case.
Evening law classes.
Where
LLB.
Your lordship knows that, of course, was a case where your lordship had enrollment in evening law classes. Evening law classes. The answer was this only, that the purpose is to exclude people from, your lordship, the whole idea is whether the purpose is valid or not. There's that old saying of Pascal, I think, therefore I am. If you adapt it for the government of India, the affidavit says, it is right because I say in my counter it is right. It really amounts to that. Now, let us kindly see Deepak Sibbal. State sought to justify legislative classification limiting enrollment in evening law classes to government employees by deploying the self-referential reasoning that the purpose was to provide legal education to only government employees. In effect, equating the classification with the purpose, your lordship struck it down in paras 18 to 20 as well as illogical and well as not sustainable. And here it applies in this way, that simply because by definition, it is only a union between man and woman, and therefore, it is out of the present petitioner's ken. Then, para 26 of my note, which is para 24 of the counter, is the same cultural ethos and societal values. Apart from the fact that this is a very general, one more thing, it pervades the counter. Not a single survey, not a single thing, statistical, Brandeis brief to say anything that this is valid. It's ipse dixit. Now, in any case, your lordship has read that judgment that societal values cannot trump equal treatment. That principle, lordship, note on the side, I've not given it here. That's para, the lordship read in the morning. You can't trump equality principles by reference to societal values. If I am here on exclusion based on discrimination, then assuming, I'm not at all accepting that societal values make it outside of the ken. But if they were, it cannot trump non-discriminatory principles. By definition, this is the second part of my para 26. By definition, equal treatment and non-discrimination requires challenging majoritarian social norms. Otherwise, there's no question of non-discrimination. Challenging societal norms, whether gender, caste, etc. Whereas if your lordship excludes all this, then the only basis for this sexual orientation test will be animus. It's a very important point. I'll not take you to the case. I've quoted it in my para 27. Let me read that. Thirdly, this leaves the only remaining legislative purpose as animus against the community and the refusal to treat them as equal moral members of society by offering them the same range of benefits as opposite sex couples. It is clear that any such purpose needs only to be stated to be rejected. Legislative purpose itself cannot be discriminatory or unconstitutional. This is the other facet of the same point. The purpose cannot be discriminatory or exclusionary. Now, the South African Constitutional Court said, the exclusion of same-sex couples from the legal institution of marriage conveys a message of unequal moral concern or respect of the Constitution. They said so in these words: the exclusion of same-sex couples from the benefits and responsibilities of marriage accordingly is not a small and tangential inconvenience resulting from a few surviving relics of societal prejudice destined to evaporate like the morning dew. It represents harsh, if oblique, statement by the law that same-sex couples are outsiders. It's the outlier which is exclusion, which is discrimination, which is Article 14, 15, and 16. It's the exclusion, the outlier. And that their need for affirmation and protection of their intimate relations as human beings is somehow less than that of heterosexual couples. It reinforces the wounding notion that they are to be treated as biological oddities. It's rather well put, as failed or lapsed human beings who do not fit into normal society, and as such do not qualify for the full moral concern and respect that our Constitution seeks to secure for everyone. It signifies that their capacity for love, commitment, and accepting responsibility is by definition less worthy than that of heterosexual couples. Whereas if your lordship were to look for the philosophical underpinning, but I say also the core constitutional value underpinning, this is rather well put. And I'm of course, it is L.B. Sachs, we know that. It's L.B. Sachs. But L.B. Sachs also could not have, he has bested himself. He's written some very, very good passages, but he has really
bested himself. Have you read his book, The Strange Alchemy of Law and Life? It's a brilliant book, actually.
But here, in a very, very pithy manner.
L.B. Sachs, there's a great story about L.B. Sachs. Sachs was very closely associated with the African National Congress.
Yes.
And, when he was driving his car once, a bomb was placed under his car, which blew up, and he lost his arm. And
I believe there is a Netflix.
Then, the Truth and Reconciliation Commission was instituted in South Africa. And Sachs has narrated the story. He went for an evening, so he was having a drink at the bar, when someone came and said to him, well, somebody wants to come and meet you. So he said, he was intrigued. So he said, well, that person can come and meet you. Can come and meet me. The person who came and said hello to him was the very person who had planted the bomb under his car.
Yes.
So, then Sachs speaks about, his sense of forgiveness and
he heavily influenced Mandela and the whole system for that concept of truth and reconciliation. He was the... But this is, if I may say so, one of the best legal statements. I have put it in my compilation, and it is almost now, elsewhere in the early part of my submission, which I have not read, we have identified 33 examples. 10 examples in 10 different countries are like this, of judicial interpretation consistent with constitutional values, not doing violence to values, bringing in marriage recognition for same-sex persons. Those 10 countries, for your lordship's information, would be Austria, Brazil, Colombia, Costa Rica, Ecuador, Mexico, South Africa, your lordship just read with me, Taiwan, and of course the US. And about 23 have legislated it. They're both examples. But these 10 I have given.
Some others which are the European human rights courts, etc.
Yes,
Russia.
Not sovereign domestic courts, but the human rights
transnational court.
So now it's expanding. This is an earlier list of about 33, of which 10 mullahs are judicial.
The earliest one was perhaps England.
What mullahs?
England, UK.
Ah, yes, yes.
England.
Yes, yes. So therefore, mullahs, and I'll be coming to a very interesting because England is believed to be much more timid, restricted, and circumscribed in its in the acrobatics which anybody can do in judicial review. I will give you an extraordinary article and two cases. How far they've gone on interpretation. Of course, identical to us because we have the Constitution. So, Your Lordship is looking today at a Constitution compliant interpretation, if I may use that word. They've done exactly the same for a treaty compliant interpretation.
That's because of the Human Rights Act.
And they've gone. No, but
the declaration of incompatibility.
I am surprised at the stand of the government of India. Your Lordship's not only has much more power, but has gone much further. In that case, I will cite, they've said that it is wrong to think that text of the statute is a limitation. It is wrong to think that even intent is a limitation. With evolving dynamics of time and society, the two tests are to make it treaty compliant, which is exactly the same as constitutional compliant. The underlying thrust of the legislation. And B, the institutional capacity of the court. And by institutional capacity, they've explained further to say it means that unless the court feels that it is being asked to naked usurpation of legislation, namely, Your Lordship goes beyond the limit, not doing some legislation, but Your Lordship is virtually asked to transgress all limits and become a legislator. Barring these two, it is wrong to say that the text is a limitation because they say text evolves over time. And intent also evolves over time. And these English courts are saying this. There's a beautiful article which I also will come in. That will take some time because Your Lordship's approach to interpretation is identical today. If Your Lordship accepts it this way or that way, but the test is the same. Your Lordship is looking in the first part of my submission not to strike down anything. Your Lordship is looking to make it compliant, constitutional compliant. Those judges in that article tells Your Lordships how they were making it treaty compliant in identical situations on an evolving dynamics of society. Then, mullahs, there is another facet, mullahs, of manifestly arbitrary. Your Lordship knows, mullahs, Article 14 to just digress, it's important to digress for 30 seconds, mullahs. Till, mullahs, Royappa, etc. I mean, broadly, there have been earlier cases. Your Lordship had only, mullahs, the discriminatory aspect. Then Your Lordship got the arbitrary aspect, just developing nascently in Royappa. Then Your Lordship carried that arbitrary aspect much further in Maneka, Ajay Hasya and all those cases, mullahs. And now, mullahs, Your Lordship has turned, mullahs, Mr. Benegal Rao and Mr. Frankfurter over in their grave by bringing in full due process. He picked up the Japanese constitution and put it in Article 21 because Mr. Frankfurter said, look, you do anything you like, but don't do this. Your Lordship, mullahs, camouflaged it by calling it procedural due process in Maneka.
Now we brought in substantive due process.
Now, mullahs, substantive due process.
Mr. Rao must have been shocked even within 2 years.
And Mr. Frankfurter would have died a second time, mullahs.
Justice Fazal actually imported it.
Yes.
It just took another 20 odd years.
And mullahs, after Maneka, where Your Lordships kept the pretense of procedural due process for a few decades, Your Lordship now has all of them, mullahs, Talaq, Triple Talaq, Joseph Shine, any number of cases, manifestly arbitrary, which is nothing but substantive due process. Now, with that background in mind, kindly consider what Your Lordship is today judging, mullahs. Your Lordship is allowing the creation of hierarchy between different conceptions of the family. It's another way of looking at the same thing, conceptually, mullahs. Your Lordship is allowing distinctions foul of 14, 15, 16 by, mullahs, having a hierarchy between different conceptions of the family, involving unions between some kinds of persons more equal than others to have unions. Of course, again, based on their descriptive characteristics. So, hierarchy, which is a sub-classification, Your Lordship will not allow in Article 14. Of course, it's another angle to look at the same thing. Don't allow hierarchization of family units between those penalized for their descriptive tendencies versus heterosexual couples.
Yes.
Your lordships brothers actually said this. Of course, not the ratio of the case, because my lords were dealing with a narrower issue about a mother with children from the first marriage. But your lordship's principle is clearly stated in my Lord Justice Chandrachud, as he then was, in Deepika Mal's atypical family units. And the para is 26. Lordship may note that para. That was cited but not read. It was cited by Mr.
Hariharan. Deepika Hariharan.
No,
Which one?
Deepika Mal's 22. That is Mal's in your lordship's compilation at page 84 at 91. Just read that one para, Mal's. My lord has put it very pithily. Atypical family units, referring to Mal's queer relationships, equally deserving. Kindly turn to that page, Mal's, just for a minute. Para 26 is that page. Is it 60? Page 91 PDF.
91?
Yes.
Volume 1. Volume 1, Sanjay. Volume 1.
Para 26.
91 PDF.
Page 91. Huh?
Page 91.
91 PDF. Returned.
That's the hierarchization created wrongly, I say, Malus. May I read?
Yes.
The predominant understanding of the concept of a family, both in the law and in society, is that it consists of a single, unchanging unit with a mother and a father who remain constant over time. This is very important, Malus. This is meaning of conception is changing. This assumption, and their children, this assumption ignores both and the many circumstances which may lead to a change in one's familial structure, and the fact that many families do not conform to this expectation to begin with. Familial relationships may take the form of domestic, unmarried partnerships or queer relationships. A household may be a single parent household for any number of reasons, including the death of a spouse, separation or divorce. I'm interested in the second part of this, but just read the next few lines. Very pithily put. A household may be a single parent household for any number of reasons, including death. Similarly, the guardians and caretakers who traditionally occupy the roles of the mother and the father, inverted commas, of children may change with remarriage, adoption or fostering. These manifestations, this is what I'm interested to read, in particular. These manifestations of love and of families may not be typical, but they are as real as their traditional counterparts. Such atypical manifestations of the family unit are equally deserving not only of protection under law, but also of the benefits available under social welfare legislation. The black letter of the law must not be relied upon to disadvantage families which are different from traditional ones. The same undoubtedly holds true for women who take on the role of motherhood in ways that may not find a place. Well, these 6 lines in the preceding in particular sum up, Balals, the Article 14 aspect which I am making separately. Atypical does not mean, Balals, the atypical application of the law. And today, Balals, when your lordship has crossed the threshold of even substantive due process, we are today being told that your lordship is, Balals, doing something very Lordship embarks on this. This completes my first and the most important pillar, non-discriminatory equal treatment. Second is freedom of expression. Freedom of expression, I had the privilege of arguing Naveen Jindal. I remember Justice Khare carried it from court 6 to court 1. That matter with him kept on getting adjourned. The government of India and Mr. Raju Ramchandran was the ASG at that time. A matter against his heart and instinct, I believe. But anyway, he did his duty,
So Naveen Jindal later became my client because he didn't hold it against me.
So, there, people tend to forget the right to fly the flag. We gave submissions, the SEC has published those submissions, 19(1)A expression. But there's one part of that, is that speech, 19(1)A, extends to, quote unquote, socially valuable participation in socially valuable forms of expression that are articulated in community. That's the facet I'm underlining only, for your Lordship's consideration. That's in Naveen Jindal, para 90. And the socially valuable forms of expression articulated in community, the participation within which is essential to be complete, is also applicable to this case of exclusion. I'm not reading Nalsa because it's been read, it's been referred. I put in my submissions. I'm strictly avoiding it, But my point in one line here is freedom of expression includes the freedom or the right to express one's gender identity in all its manifestations. That's my proposition as far as this topic is concerned. Now, if you are in 19(1)A, and it's a straight point of 19(1)A, we don't need to spend time on 19(1)A. This phrase is sufficient. These two phrases, participation in socially valuable forms of expression in the community, and freedom of expression includes the freedom to express one's gender identity. These are the two principles. The question arises, under what part of 19(2) can you touch it? Which 19(2) have you shown to the court? That's the more important aspect. It can't be, it is not. There is no reference point to any facet of 19(2) which there cannot be. You can stretch decency and morality. You can stretch decency and morality. Is in action to
Down on 19(2), there is no law which is a reasonable restriction.
There is none.
14, yes, 14, 15, whatever. But the silence of a law to be construed as an
I am very grateful. That's the second aspect. Today, your lordships has got, first, let us forget the silence of the law. First point is, if a law was made, I'm now going very much further against me than I need to go. Which part of 19(2) can it be relatable to? When the core values of the constitutional lordship is already discussing.
Then we are into an academic
question, correct? But decency and morality, you cannot stretch anywhere near to this. Your lordship is talking of constitutional morality and all the other. Number two.
No, if that's a hypothetical situation, that if you make a law and exclude today.
You may test it later on if it may.
Otherwise, today is a default argument.
Now,
you have not made it, you have not included it in there. Therefore, you read it in this.
No, but I'm only saying something else. I'm saying hypothetically only. I'm saying only hypothetically. My Lord Justice Bhatt is right. I'm saying hypothetically, the very text of 19(2) doesn't make it easy to think of a law which can be made, but I understand it's only hypothetical. It's an hypothetical argument made to show the contrast. Second, it is much worse because, I'm sorry. Now, the third and the last prong before I come to the very interesting interpretation part is the dignity point, which your Lordship is well aware, Article 21. I'm sorry, I forgot. I'm very sorry before I leave that. Well, it's this last part. This is actually the intersection. Main is Article 14 and 15, 16. This last point is an intersection of 14 with 19(1)(a). The right to express one's gender identity is being questioned by the state, of course, without a law under 19(2), questioned on the ground that what right heterosexual couples have to project that identity, non-heterosexual couples do not have. So it's an intersection of 14 and 19(1)(a). The projection of the gender identity, which is a part of free speech, free expression, is inhibited by your stand, which allows that right unfettered in your heterosexual category. And Malas, if they can't do it for a heterosexual couple, because your Lordship will undoubtedly hold it to be unreasonable restriction, then how is it a reasonable restriction for me?
That is happening. You can comprehend what you are driving. The absence of a restriction per se. Today, if you say that today if this
No, I'm saying the silence is being read as a restriction. I'm saying, Malas, no, my Lord, I'm saying the silence is read in the counter and the stand of the government is a restriction. That's the meaning. Malas, I understand. I'm saying it's impliedly there. You have to read it there.
It's not so much a statutory silence as much as the failure of
to allow. They're not going to allow it.
To enact a law.
Well, it's more than failure to enact. They will not recognize. I'm not going to go in the market with the label of marriage only. If I do anything on the basis of that marriage, who's going to recognize it, Malas?
In argument.
No, that is the right part. I'm saying, Malas, their restriction. Third pillar is dignity. That is, Malas, very clear. Based on Article 21 as a third pillar or third facet. And Malas, there. Everyone with equal concern and respect is the core of that dignity. If you were to, Malas, specify.
I just missed the point.
I
just missed the point, sorry.
No, I'm saying the third pillar. We're done with those two
Dignity
pillars.
part of it.
The last one is, Malas, of course, the intersection. Of course, 14 is vital in the intersection. And to what Justice Kohli also said, apropos Justice Bhatt, lack of recognition is actually a full restriction, de facto, de jure. Now, coming to the third pillar, dignity. Dignity, is Article 21, obviously resides there. And your Lordship has put it, differently, but the best, simplest way of putting it is to treat everyone with equal concern and respect, and not to send a message that any individual is less worth because of their ascriptive characteristics. That any group is less worth because of their ascriptive characteristics. And with it comes the ability to participate on an equal footing in social values or constructs. That also is a part of dignity. That's the entirety of dignity part. I only want to read one para as I leave dignity and come to the very important interpretation part. Just one para 40 of my written submissions. That is at page 438. I'm very grateful. 39. I'll read 39 and 40 if your Lord shall permit me. Does my Lord Justice call Justice? Chief Justice has got it. Yes. The central importance of marriage as a social institution, as outlined above, means that the ability to participate in it on equal terms is a question of dignity. When the state excludes a set of people from participation in a valuable social institution by comparing their choice with the state, proscribing what it considers noxious business activities, it communicates both to the excluded and to the rest of society that these individuals are less than complete members of society. It is therefore a message of subordination. I'm very grateful, my Lord's directed me and gave me an opportunity. 40. Now, this is by way of analogy. This is not the case we are in. Just very quickly go through 40. It gives your Lordship 3 or 4, your Lordship's juristic analogies. There are many historical instances of the exclusion of a group of people from a social institution being used to send a public message about their worth as equal moral members of society. These, for example, include caste-based restrictions on temple entry, exclusion. Very well-known case, Venkatamana Devaru. Rules that prohibited women from participating in male professions, my Lord has already read it, so I'm leaving it, Anuj Garg. The refusal to accommodate disability in public examinations, I'm leaving it, Vikas Kumar. That's also by my Lord Justice Chandrachud. And many others. Over time, laws and the judgments of this court have removed these exclusions on the understanding that the ability to participate in the making and remaking of social institutions is central to individual dignity. The exclusion of LGBT, etc., from the social institution of marriage is one of the last remaining legal outposts that sanctions such exclusion. And therefore, it would advance the constitutional goal. This completes the 3 constitutional pillars and the ascriptive test. I now come to something very interesting, where in different contexts, in 3 judgments, in the House of Lords in the UK Supreme Court, one of the two judgments was very beautifully put. The issue arose, of course, it arose in the Rent Act in one case and some landlord relation in the other, that Parliament A did not intend it, or the text is a limitation, or the intent is a limitation, and how should we as a court read it? But fortunately, it arose, how should the court read it as a treaty-compliant legislation, not merely interpretation. In that, I'll read first one case, then a very, very well-written article, and then the other 2 cases. That's going to be, I believe, very profitable and repay study. First, turn to the House of Lords in a case called Ghedan. Now, this is in volume 4, which is foreign judgments. And
this interpretation part of it, you haven't dealt in your written submissions, no?
Which one? No, I've not called it interpretation. I've called it remedies. But it's, well, your lordship will not understand it quite clearly unless I read the judgment.
All right.
I'll come back to it, but my lord is right. It is fully there under the heading
Remedies.
remedies. But minus that brilliant article, Malas, which I have not been able to. I've got it ready in hand for giving a copy, but Malas, it's not in the.
277. Into 277.
Yes, yes. In one Malas, this is very important. May I summarize it? Constitutional compliant interpretation of a statute oblique treaty compliant, because your lordship is dealing with a treaty case, oblique treaty compliant, which is their constitution. The treaty is their constitution. Constitution compliant interpretation oblique treaty compliant interpretation of a statute is not limited by the statutory text or the legislative intent. But in a dynamic, evolving context, only, the word only is important, only by underlying thrust of the legislation and by institutional capacity of the court. And institutional capacity is explained, Manas. This is 113. 32. Ghedan. I start with Ghedan, Manas, which is para 32 at 1136 of your lordship's PDF of volume 4, which is foreign judgments.
Para 32.
Give me one page. 1146. I'm sorry, I gave the wrong page. But what is third part? Just write down.
What page?
1146 of foreign judgments, volume 4.
Yes, what para you refer?
32.
1146? PDF.
PDF. Is it para 32? My learned friend says it is 1146, para 32.
Is 1146 is actually physical 1138.
38.
Physical 1138.
May I read? From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with the convention compliant meaning does not of itself make a convention compliant interpretation under 3 impossible. Section 3 enables language to be interpreted restrictively or expansively. But Section 3 goes further than this. Take out the page where Section 3 is quoted. Take it out. It is also apt to require a court to read in words which change the meaning of the enacted legislation to make it convention compliant. Will my lord underline that? The lordship got that sentence. In other words, the intention of Parliament in enacting Section 3 was, to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of primary and secondary legislation. As I've studied in England, I could not imagine these words coming from an English court. Parliament, however, cannot have intended that in the discharge of this extended interpretive function, the court should adopt a meaning inconsistent with a fundamental feature of legislation. That would be to cross the constitutional boundary under Section 3. Section 3 seeks to demarcate and preserve. So it's nicely balanced. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of Section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble and learned friend Lord Roger, go with the grain of the legislation. Nor can Parliament have intended that Section 3 should require courts to make decisions for which they were not equipped. There are several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. Now, let's kindly come to para 51. Please give me the sequence.
Was an issue.
Whereas this was
This
Rent Act,
children.
the phrase was as his or her wife or husband. Now, this is very important. Let's just write down this sentence. It's a very important query which Lord is raised. What was the context? Identical to us. The phrase under the Rent Act was, just kindly note that down, Lord should take my word for it, as his or her wife or husband. And the finding was that this phrase means as if they were his wife or husband. As if they were his wife or husband. That is the finding. In other words, they were not husband and wife, but we have to read it as if they were husband and wife.
Just the para 35, there
Yes.
it's very interesting. That will give you the facts and how they mold the.
Yes, may I, Melissa?
The relief.
Lord Stein is very important. Let me read 35 first.
35.
In some cases, difficult problems may arise. No difficulty arises in the present case. Paragraph 2 of Schedule 1 of the Rent Act is unambiguous. But the social policy underlying the 1988 extension of security of tenure under Para 2 to the survivor of couples living together as husband and wife is equally applicable to the survivor of homosexual couples living together in a close and stable relationship. And this is a country doing a convention compliant interpretation with no constitutional history, hardly any constitutional jurisprudence and legacy. In this circumstance, I see no reason to doubt that application of Section 3 to Para 2 has the effect that Para 2 should be read and given effect to as though the survivor of such a homosexual couple were the surviving spouse of the original tenant. That's how they read it. Reading Para 2 in this way would have the result that cohabiting heterosexual couples and cohabiting heterosexual couples would be treated alike, for the purposes of succession as a statutory tenant. This would eliminate the discriminatory effect of Para 2 and would do so consistently with the social policy underlying Para 2. Without Article 14. Without Article 14. Now, just read on. There's something more. I've not finished. This is a very interesting case. And the article is even more interesting. How far then? Now, just turn to Lord Stein, who's the next para. He, of course, the summary is better to see first. Para 51, which is at page 1152. Nothing else. But nothing else. I now return, it's at 1152, my Lord has got, the conclusion of Lord Stein.
You've got that.
I now turn to the circumstances of the case before this House. Applying Section 3, the Court of Appeal interpreted as his or her wife or husband in the statute to mean as if they were his wife or husband. While there has been some controversy about aspects of the reasoning of the Court of Appeal, I would endorse the reasoning on the use of Section 3(1). It was well within the power under this provision. But Ballad's possibly the best way of putting it was Lady Hale Ballad's, which is at 1177. The first Ballad's woman Chief Justice, not right way to describe her, of UK. President of the UK Supreme Court. Which page is it?
1177.
1177. Well, it's 1177, para 130.
Seven.
130.
Para as well as 130.
30.
PDF
Okay,
117.
Baroness Hale of Richmond.
May I read, Willis?
1177.
Yeah, para
11? I believe it's 1177.
They were on.
Same volume, little ahead.
Baroness Hill of Richmond.
Well, she has put it on a wider one, but I will read some paras on a wider basis, but also this basis.
Yeah.
And rather well put. Sure you've not left out any? It is, may I read, Manas?
Yeah.
It is not so very long ago in this country that people might be refused access to a so-called public bar because of their sex or color of their skin. That a woman might automatically be paid 3/4 of a man, what a man was paid for doing exactly the same job. That a landlady offering rooms to let might lawfully put a no blacks notice in her window. We must now realize that this was wrong. It was wrong because the sex or color of the person was simply irrelevant to the choice which was being made, to whether he or she would be a fit and proper person to have a drink with others in the bar, to how well she might do the job, to how good a tenant or lodger he might be. It was wrong because it depended on stereotypical assumptions about what a woman or a black person might be like, assumptions which had nothing to do with the qualities of the individual involved. Ascriptive. Even if there were any reason to believe that more women than men had bad customers, this was no justification for discriminating against all women. It was wrong because it was based on an irrelevant characteristic which the woman or the black did not choose and could do nothing about. Ascriptive. When this country legislated to ban both race and sex discrimination, there were, and we have here a Hindu prime minister and a Muslim first secretary in the north of that country. First minister, which is the equivalent of the prime minister within the sovereign system. When this country legislated to ban both race and sex discrimination, there were some who thought such matters trivial, but of course they were not trivial to the people concerned. Still less trivial are the rights and freedoms set out in the European Convention. The state's duty under Article 14, now it is interesting that number is the same, to secure that those rights and freedoms are enjoyed without discrimination based on such suspect grounds, is fundamental to the scheme of the convention as a whole. It would be a poor human rights instrument indeed if it obliged the state to respect the homes or private lives of one group of people, but not the homes or private lives of another. Such a guarantee of equal treatment is also essential to democracy. Democracy is founded on the principle that each individual has equal value. Treating some as automatically having less value than others not only causes pain and distress to that person, but also violates his or her dignity as a human being. The essence of the convention, as has been said often, is respect for human dignity and human freedom. See so and so. Second, such treatment is damaging to society as a whole. Wrongly to assume that some people have talent and others do not is a huge waste of human resources. It also damages social cohesion, creating not only an underclass, but an underclass with a rational grievance. Third, it is the reverse of the national behavior we now expect of government and the state. Power must not be exercised arbitrarily. If distinctions are to be drawn, particularly upon a group basis, it is an important discipline to look for a rational basis for those distinctions. Classification, nexus, object. Finally, it is a purpose to all human rights instruments to secure the protection of the essential rights of members of minority groups, even where they are unpopular with the majority. Minority includes minority in different ways on ascriptive characteristics. Democracy values everyone equally, even if the majority does not. Then, para 137. I hope we have not missed out anything, right?
I think you may read 135 also.
135. May I read? I'm grateful. It is common ground that one of the convention rights is engaged here. Everyone has the right to respect for their home. This does not mean that the state or anyone else has to supply everyone with a home. Nor does it mean that the state has to grant everyone a secure right to live in their home. But if it does grant that right to some, it must not withhold it from others in the same or an analogous situation. This is the heart of equality. There's no positive obligation that says I must give you a house. It must grant that right equally unless the difference in treatment can be objectively justified. You're granting marriage to heterosexual couples. Give me a rational reason to deny it to this side of the table. There is no need for us to express a view on the degree which a constitutional right must be engaged in order to bring Article 14 into play on any view that threshold is crossed here. It is also common that there is a difference in treatment in respect of that right between the respondent and the survivor of an opposite sex relationship. It is also common ground that sexual orientation is one of the grounds covered by Article 14, on which, like sex and race, a difference in treatment is particularly suspect. Well, this is that facially suspect, which your Lordship has said. Yeah. Facially, well, for the reason given earlier, the grounds put forward to justify it require careful scrutiny. Now, 137. The parties differ on whether the survivors of an unmarried heterosexual and homosexual couples, so he's dealing with unmarried and homosexual couples both, are indeed in an analogous situation, and therefore on whether the basis of the difference in treatment is sexual orientation or something else. Impossible to see what else the difference can be based on. Impossible to see what else the difference can be based on except sexual orientation. Everything which has been suggested to make a difference between the appellant and the other surviving partners comes down to the fact that he was of the same sex as the deceased tenant. It is the decisive factor. Then, Wallace, 38, in fact, I'll also read. We are not here concerned with the difference in treatment between married and unmarried couples. The European Commission accepts, etc. May I, Wallace, come, if I don't miss out something relevant, Wallace, 142, I think, will suffice. Well, let's just see 141, the first few lines, not the whole. 141, a few lines. There are some important things. The relevant difference which has been urged upon us is that a heterosexual couple may have children, whereas a homosexual couple cannot. But this too cannot be a relevant difference in determining whether a relationship can be considered marriage-like for the purpose of Rent Act. First, the capacity to bear or beget children has never been a prerequisite for a marriage in English law. It's a very interesting history, Willis. Henry VIII, a very infamous ruler with 6 wives, would not otherwise have had the problems he did.
Not together.
No, but no. What she's saying is, that sequentially, only because of lack of children.
Right.
And in his case, lack of
an heir.
Lack of an heir. And in his case, lack of an heir meant sometimes execution of the lady. That's how, Willis, this is called, she's referring to sequential. She put it rather, Willis, in the typical English understatement. Henry VIII would not otherwise have had the problems he had. It's put it very nicely, Willis. Even the capacity to consummate the marriage only matters if one of the parties thinks it matters. If they are both content, the marriage is valid. A marriage, let alone a relationship analogous to marriage, can exist without either the presence or the possibility of children from that relationship. Secondly, however, the presence of children is a relevant factor in deciding whether a relationship is marriage-like. But if the couple are bringing up children together, it is unlikely to matter whether or not they are biological children of both parties. Both married and unmarried couples, both homosexual and heterosexual. I'm sorry. Both married and unmarried, both homosexual and heterosexual will bring up children together. One or both may have children from another relationship. This is not at all uncommon in lesbian relationships, and the court may grant them a shared residence order so that they may share parental responsibility. A lesbian couple may have children by donor insemination who are brought up as children to them both. It is not uncommon for each of them to bear a child in this way. A gay or lesbian couple may foster other people's children. When the relevant section of the Adoption Act of 2002 are brought into force, they'll be able to adopt. This means they will indeed have a child together in the eyes of law. Thirdly, however, there is absolutely no reason to think that protection given by the Rent Act to the surviving partner's home was given for the sake of couples' children. Statutes usually make it plain if they wish to protect minor children. These days, the succession is likely to take place after any children have grown up and left home. Children, whether adult or minor, who are still living in the home may succeed as members of the family under so-and-so of the schedule. It is the long-standing social and economic interdependence, which may or may not be the product of having brought up children together, that qualifies for the protection of the Act. In the days when the tenant was likely to be a man with a dependent wife, it was understandable that preference was given to the widow over anyone else in the family. But in 1980, that preference extended to widowers, whether or not they were dependent upon the deceased wife.
Dr. Singhvi, we have a similar case, except that it's not same sex. Here was a case where, in the absence, marriage was not essential. Person was living with the original tenant.
Yeah.
The tenant died.
Yes.
So the live-in, whoever was a partner.
Like you're not married.
Not married. So therefore, that protection was sought to be taken away.
More importantly, how would you read the act which might violate your
judgment by Justice Lahoti before the domestic violence act,
I'll have
where
that.
they were where the parties got estranged.
I'll cite that tomorrow. I'll let.
And then the husband, he actually intentionally walked away, and then the wife faced eviction.
Eviction.
The court granted that protection.
Now see what is the next para. I'll place that. Just see the next para. Now 142 onwards is where I particularly wanted to read. Homosexual couples can have exactly the same sort of interdependent couple relationship as heterosexuals can. Sexual orientation defines the sort of person with whom one wishes to have sexual relations. It requires another person to express itself. Some people, whether heterosexual or homosexual, may be satisfied with casual or transient relationship. Now, this is another important facet I forgot to mention, is casual or transient relationships. It is to avoid them that marriage is an important aim or object of some people. It requires another person to express. But most human beings eventually want more than that. They want love. I started the case arguing today with that one. It's the right to love person of your choice. And with love, they often want not only the warmth, but also a sense of belonging to one another, which is the essence of being a couple. And many couples also want to come to stability and permanence, which go with sharing a home and a life together, with or without the children, who for many people go on to make a family. In this, people of homosexual orientation are no different from people of heterosexual orientation. It follows that a homosexual couple whose relationship is marriage-like, look at that word, Manas, marriage-like, in the same way that an unmarried heterosexual couple's relationship is marriage-like, are indeed in an analogous situation. Manas, I can continue. There's something more here, so I'll continue tomorrow, Manas, on this. Para 143. Well, I'll be as fast. I'm not repeating anything. Just the reading time will take some. I'll be as fast as possible. I've taken the cue from Justice Kaul's comment. I will not take time. I'll do it. If your lordship would permit me, I can do it virtually, but otherwise I'll be here physically. Whichever way your lordship would say it. Very well.